May I have your attention, please? All rise. Lawrence County Municipal Court's now in session. The Honorable Donald R. Capper presiding. All those having business before the court draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. I'm Judge Capper. We're doing reviews now, so people who have reviews need to be in the courtroom. Come up to the table to your right when the bailiff calls your name.
Jeremy Alexander, Heather Chin, Dakota Kraft, Angela Dehart, Joshua Hay, Elizabeth Hoffman Howard, Justin Lehman.
Your name was called. Come forward. Jeremy Alexander, 21-1967. Jeremy Alexander. Been called for, has not appeared.
Your Honor, he wasn't here for community service when he was over.
All right, so there'll be a warrant. He hasn't finished. There'll be a warrant issued for failure to appear. It's case number 21-1967. Heather Chin's not here. That's disappointing. 2017-61, 2017-11, 2010-86. Be a warrant issued for her arrest. Her uncle's picture is hanging on the back wall. Dakota Kraft, 23-20. 22-130. So what's going on with you, Mr. Kraft?
I'm back in treatment at Bethesda.
Okay, and I don't see anybody from Bethesda. Is there anyone here from Bethesda?
I think Taylor's on the way.
Yeah, I have not seen her this morning, Your Honor.
Okay. Why don't you just have a seat and we'll recall you once Taylor gets here so I can get a report on what you're doing.
Yes, sir.
Angela Dehart, 23-681. She's a Bethesda also, so I'll put that aside. Joshua Hay, 21-24, is here. And you just have to pay off your fines now. Do you have a payment?
I did a couple of days community service down at the dog pound. I just forgot to bring the paper up here. I talked to Josh about it.
He did come and speak to me about it, and I told him I need to prove that, Your Honor.
Okay, get that in. June 24th will be your next hearing.
Thank you, Your Honor.
You're up. 9 o'clock. Elizabeth Hoffman Howard. She had called a week ago and said she was sick that day, and I gave her a continuance to today. She still hasn't appeared, so there'll be a warrant issued for failure to appear. Justin Lehman.
Yes, sir.
2688. It's at RRS. Good drug screen.
Your Honor, he's doing great in treatment.
It's a very good report. Because you're a role model for other people that are doing treatment. You've been at it for a while. Since last September. Okay, and you've paid off your fines and everything. I think you should continue with whatever you need to do with RRS to stay clean and sober, but I'm going to mark your case as completed. Congratulations, you've done well. Thank you.
Thank you, Your Honor.
You're welcome.
Roderick Keith Lewis, Shannon L. Lewis, Donald Porter, Michael Rowe, Alexis M. Shockley, Matthew S. Smith, Brenda Wolf, Justin Tyler.
Roderick Lewis. Okay.
Your Honor, since the last time we spoke about Roderick, he has expressed that he is not going to continue services with us.
Okay. Well, he hasn't appeared, he's done very little on his case, so he'll get a warrant issued.
Thank you, Your Honor.
Thank you. And there should also be a license suspension issue. It should be for the full 3 years. He had a 3-year suspension reduced down to 6 months. He hasn't completed, so now it should be for 3 years. Shannon Lewis, 23-427, Shannon Lewis. And he's also a possessor, so I'll put him aside. Donald Porter is here. Case number 20-2120.
Just received from paying money.
18-1242, 08-441. Let's see. Do you have a payment?
I made a payment Monday.
May 20.
Yeah, I'm trying to make 2 20-hour payments a month leases.
Okay, I see you made a payment. All right, June 24th will be your next hearing, 9 o'clock.
Thank you, June 24th.
Exactly 1 month. Michael Rowe.
Your Honor, if I may, he turned in 2.5 hours of community services.
Okay. Case number is 23-4, so that'll go toward his fine. It appears that that's what he had left. All right, I'll set your next hearing for July the 19th.
July 19th. All right, thank you, Your Honor.
You're welcome. Alexis Shockley.
I'm here, Judge.
All right, she's appearing by teleconference, 23-696. Okay. You've got community service to do.
Yes, sir.
Okay, when can you do that?
I plan on coming this week, but my car is broke down right now, so I'm hoping next week
Where do you live?
in Westmoreland and Huntington.
Okay. Well, you got 5 days to do. You paid some of your fine, you still have $155 left.
Yes, sir. I'm paying that today when I get paid.
Okay. This was your first review, so I'm going to give you more time than some of the others.
Okay.
July 19th, if you finish up, you don't have to come back. July 19th, 9
Okay.
o'clock. You should get it finished.
All right.
That's all.
All right. Thank you.
You're welcome. Matthew Smith is here. Okay, you've got community service to do still.
Your Honor, if I may, I have a note that on April 22nd, Mr. Smith was ordered to do some community service before his next hearing.
And it happened. What do you say, Mr. Smith?
I didn't know I was ordered to do it. I just knew that I had 30 hours to complete. I wasn't aware that I was ordered to. I wrote the dates down, but I was honestly not aware that I was ordered to do them. I know I have them to do, but I just didn't know that I was ordered to do them.
Okay, I'm going to place you in custody and we'll think about it, and I'll have you out at the end of the docket, decide how we're gonna handle it. So
Okay.
you're committed into the custody. Brenda Wolf, 141025. You have done some community service since your last. You still got 3 days left, and you have just $30 left on your fine.
Right, I'm gonna pay the fine on the 3rd, and I thought I only had 2 days of community service left.
Well, you can talk, maybe it hadn't been updated since you, well, it probably hasn't been updated since you did 6 hours, so.
Yeah,
maybe-
I came in twice.
Okay, you talk to Mr. Major about that. I'll set
Yes.
your next hearing for June 24th, 9 o'clock.
Yes, sir.
Get it finished, you don't have to come in after you get it finished.
Yes, sir. Thank you.
You're welcome. Justin Taylor, case number 23-385. This is on an OVI. Community service is done. You made a payment today. I don't see, have you done the driver intervention program yet?
No, they're opening a new one up here,
Right.
correct? It's gonna be a
Starting
little bit
next month.
cheaper than the one in Portsmouth?
No, I think it's the same
Same?
price, is my understanding.
Okay.
There is a cheaper one in Chillicothe. You can go to any one that's approved by the state of Ohio. But I believe the one in Saddle County and the one that's starting here in Lawrence County are gonna be the same price.
Okay.
But the legislature tells me I gotta either put you in jail or make you go to that program. So I'm assuming you'd rather do that program than go to
Yes.
jail. Good choice. But get it done. Yours is a newer case, so I'm gonna go into July for your next review. So let's make it after, so you'll have a couple chances to get the DIP program done. I'll make it July 19th also. If you get that done and pay off your fine, you don't have to come back.
Alrighty, thank you.
July 19th, 9 o'clock.
Thank you.
You're welcome. All right, so I'm still waiting on Taylor to get, she is coming?
Taylor's not here yet.
She is coming, okay, so when she gets here, we'll recall the Bethesda folks. We're ready to start the arraignments, so if you're here for a new case, anybody outside, we're not having court out there, so if you got a case, you need to come in. Unless you want to wait till the end of the docket. Just wait for folks to come in. If you have a new case, or you got a warrant issued on an old case because you missed a hearing or something, then you're going to get called with these new cases. And if you don't get called, you think you should have been, if we don't know you're here, like you had a case before and you didn't show up, we're not going to know you're here unless you go check in with the clerk, and they'll know and put you in the docket. When your name's called, come up to the table to the right. You have a right to remain silent. You don't have to say anything, but what you do say is on the record. And I have people blurt out craziest things sometimes. This is not the trial, so I'm not going to say, oh, you know, you're right. I'm just going to throw it all out today. That doesn't happen. So you getting up and giving me a big explanation about what happened could hurt your case, because it's like testimony. You're saying it right here on the record, it's being recorded. So remember, you have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail. You have a right to make the state prove any charge beyond a reasonable doubt. Those are your rights. You waive those rights by entering a guilty plea or a no contest plea. So don't enter those pleas if you don't understand what's happening, if you're confused, if you want to talk to a lawyer, or if you want a trial in your case. You need to enter a not guilty plea. Call the first case.
State of Ohio versus Brandon T. Lovelace, case number TRC 24-1034, A, B, and C. Brandon Lovelace.
Brandon Lovelace was cited to be here today by the Ohio State Highway Patrol, 9 a.m. It's after that, has not appeared. There'll be a capias issued for the arrest of Mr. Lovelace. Failure to appear.
State of Ohio,
There should also be a suspension. He's an out-of-stater, Tennessee, so we should send in a suspension to the B&B so they'll notify Tennessee to suspend his license.
State of Ohio versus Garrett A. Childers, case number CRB 24221.
Sir, are you Garrett Childers?
Yes, sir.
All right, Mr. Childers, it's alleged that on February 12th, this is an old case, February 12th of this year in Union Township, you recklessly caused inconvenience, annoyance, alarm to others by engaging in fighting, threatening other persons of their property, being violent or turbulent, and that this was committed in the vicinity of a school. So that's a 4th degree misdemeanor, maximum penalty 30 days in jail, $250 fine. Do you understand this charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty?
Do you wish to have a lawyer appointed to represent you?
Yes, sir.
And you're a student?
I graduated.
Okay, well, just recent. You
Well,
were in
yes.
school this year. So do you have a job?
Yes, sir.
What do you do?
I'm working at McDonald's right now.
Okay, well, you're going to be eligible for a court-appointed lawyer then. So I'll appoint Mr. Steyer to represent Mr. Childers. We'll get Mr. Steyer in here. Mr. Steyer, this is Garrett Childers, 4th degree misdemeanor. He is a recent high school graduate. I think this may have happened in some connection with school. So I'm appointing you to represent him. Not guilty plea has been entered for pretrial.
I have to look. Do you have this? I put on email.
I could do the 7th, the 14th, 17th. Those days work.
7th would be best, Your Honor, those days.
June 7th will be the next hearing. It'll be a pretrial at 10 a.m. June 7th, 10 a.m. Not guilty pleas in it.
All right, I'm going to get the court's file. I'm not used to
Oh,
that.
he can sign a $1,000 OR bond.
Here, that's your next date, do that.
State of Ohio recalls Shannon L. Lewis, case number TRC 23-27, A and B.
Shannon Lewis, this was a Bethesda case. It's called before it did not appear.
Sorry, Your Honor. He is in services and is doing well. He had to work last night, midnights at the Huntington Mission. But he's compliant with all services and he actually completed his remedial class this last week.
All right. I'll set, I had a note on here to set for July 1st, so I'm going to keep that date. I don't know if there's in the computer as well, so to say. It's on the file marked as July 1st. Make sure that's correct. Yeah, that's a Monday. July 1st is his next hearing.
All right, thank you, Your Honor.
You might as well just stay up because we got 2 more hours.
State of Ohio versus Angela DeHart,
She is in STAR.
Okay.
CRB 23-681.
Did she go there from Bethesda?
She got in trouble and went before Judge Ballard again on an ILC violation, and he sent her to STAR.
Okay. She She had like a Walmart theft offense here. She was ordered to treatment. And the only thing she had was court costs. So since she's been incarcerated, then I'm just going to complete this case by jail time. So she's completed by jail time. We won't, since they're tracking her in common pleas, we won't track her here anymore. But she's completed by jail, so her case is completed.
State of Ohio versus recalls Dakota Crafts, case number CRB 2320 and CRB 22130.
Dakota is doing well and getting acclimated to treatment. We're looking at the needs to make sure that we can ensure that this doesn't happen again.
Okay. I'll set his next hearing for June 24th, 9 a.m. Okay, good report.
Thanks, sir.
That's it. Thank you.
State of Ohio versus Carrie Craig, case number CRB 24240. Carrie Craig.
Gary Craig. Okay. I don't have proof of good service in this case. She's not here, but I can't tell that she's been served with the summons, so I will pass it for service.
Your Honor, who did you just call for?
Yeah, Carrie Craig.
She's here. She just brought in her paperwork. Ms. Craig,
Carrie Craig, come up, please.
here's your paperwork back. So she was served. She has her son here. Yeah.
You are Carrie Craig?
Yes, sir.
Ms. Craig, you have a charge filed at Union Township on April the 18th while you were engaged in hunting and accompanied by the owner or keeper of the dog. Did fail to keep the dog confined or on a leash. That's a minor misdemeanor, maximum penalty is a $150 fine.
Okay.
I don't know what the hunting has to do with it, that's in the complaint. This is a minor misdemeanor, the maximum penalty is a $150 fine. How do you plead to the charge?
Guilty.
Okay, that means you're admitting it's true. Okay, I've got an affidavit from a deputy Frame from the Lawrence County Sheriff's Office that says, I was dispatched to 284 Township Road 1379 for an animal complaint call. When I arrived, I was approached by a female identified as Brandy Henson. She said she spoke with her neighbor numerous times about their dog running loose and acts aggressive toward her mother. And she was afraid to come out and go to the mailbox. Since advised, she came to pick up her son, went to check the mail for her mother. The dog came after her and attempted to bite her. She attempted to contact the owner, but could not. On April 17th, I did a follow-up with the owner. When I arrived, I attempted to make contact, did not, approached, spoke with Ms. Henson's mother, who was identified as Veronica Hamlin. Asked if she knew the name of the owner. She advised me the name was Carrie, but was unsure of the last name. Asked her if she could make contact with her daughter. She knew, and advised that it was Carrie Craig. Asked Ms. Henson if the dog ever left the residence. She advised yes. No, that was it. Okay, so what do you have to say about this? What kind of dog is it?
He's a little fuzzy dog. I don't know what kind he is.
Okay.
But if she wouldn't kick at him and stuff, he probably wouldn't try to bite her.
And where is this? Where's Township Road 1379?
North Huntington Heights in Chesapeake.
Okay. Well, most people maybe don't know, but you know there is a leash law in Ohio. You got to keep your dog either on a leash or on your property confined by a fence or whatever means Your dog's not allowed to run the neighborhood. It's not supposed to be out in the street, it's not supposed to be on your neighbor's property. I mean, I know a lot of people don't do that, they let their dogs run wherever they want to run, but that's against the law. So, here's what I'm going to do, which the dog warden doesn't like, but I'm going to give you a $100 fine, but I'm going to suspend it on the condition that you start keeping the dog out.
I'm trying to get rid of him.
Okay?
I'm waiting on the dog pound.
You can do that too.
Yeah.
If you don't think you can keep them up, then
No,
give
he
them to
breaks
somebody else.
everything.
But, you know, either put them on a leash or get a fence or a pin or whatever, but you can't let them run out and run loose, especially if your neighbors don't like it. They can call the sheriff and you'll wind up getting a citation for it. So,
Yeah, I've been keeping him up, so.
okay. So I'm going to order you to pay the court costs, so that's bad enough.
Okay.
So that's $125. Court costs $125 with no fine. Do you need time to pay it?
Yes.
Okay.
Probably payments too, if necessary, if possible.
All right, I'll set it up on a final pay date of August 27th, so you got all summer, basically, to get it paid.
Good deal.
So you got to pay it by then, or we'll send it in as a failure to pay. Any questions? Okay, you're free to go. Keep your dog up or get rid of it.
Thank you.
You're welcome.
State of Ohio versus Robert D. Fox, case number TRC 24-1009.
You're Robert D. Fox?
Yes, sir.
Mr. Fox, the state's filed a complaint alleging that on May the 18th at 1:33 a.m. in Fayette Township, you were operating a vehicle while you're under the influence of either alcohol, drugs, or a combination of those things, and that this would be a second offense for you. On a second offense, the maximum penalty is 6 months in jail, $1,625 fine, and a 5-year license suspension. That's the most the court can impose. There is a minimum, so the least you can get on a second offense is 10 days in jail, $525 fine, and a 1-year license suspension. And if the vehicle's titled to you, it's required to be impounded for 90 days. And I don't see if they, let me check, see if they filed. They did file paperwork saying it was titled to you, so it would be subject to impoundment if you're found guilty of this offense. Do you understand the possible penalties on that charge?
Yes, sir.
Then you're also charged with driving outside your lane. That's a minor misdemeanor. Maximum penalty is $150 fine. You understand the total
Yes, sir.
charges? Were you here when I explained the rights that defendants have?
Yes, sir.
Any questions before you enter a plea?
No, sir.
What plea do you wish to enter?
Not guilty.
You want a lawyer appointed to represent?
Yes, sir.
Are you working?
Yes, sir.
What do you do?
I'm working environmental service at King's Daughters Hospital.
Are you paid by the hour?
Yes, sir.
How much per hour?
$14.44.
How many hours a week?
40.
Do you have children?
Yes, sir.
How many?
3.
Are you supporting them?
2 of them.
Okay. You're eligible for court-appointed counsel then. I'll appoint Mr. Thompson to represent you. Get him in the courtroom and introduce you, Mr. Thompson. This is Robert Fox, second offense OVI. I'm going to allow him to sign a $2,000 signature bond. There's, it was alleged to be a refusal, so we're not waiting on tests or anything. I'm looking at June the 14th or after for the next hearing. Do you have a
It's
preference?
a Monday.
The 17th.
Okay.
June 17th for a pretrial at 10 a.m.
Thank you.
Next Saturday.
Thank you.
You're welcome.
Thanks, sir.
State of Ohio versus Emily A. Smith, Case number CRB 23-627. Yes.
May I approach your honor?
Yes. All right, so I think, as I recall, I wasn't here, I think she went to, now there was a facility, was it Mended Reeds, and you left her, now you self-reported to OVP?
Yes.
And when did, you know when that happened?
She
On the
came to
20th?
us on the 20th of May.
Okay.
She'll be due to complete on June 20th, and,
So that
we
was
have-
Monday.
yeah. We have discussed like her issues with leaving treatment and things like that, and she shared with me that it's kind of just impulsiveness because people around here are so willing to just come take her from treatment. So her plan at this point is to try to continue to long-term treatment, maybe a little bit further away from here. So if you will allow her to complete OVP, we will work closely with her to try to find an aftercare plan that suits her needs.
Mr. Major?
I believe we need to do a drug screen on her today, Your Honor, see what happens, where we're at.
Okay, let's do a urine screen, then we'll decide where to go.
Okay.
State of Ohio versus Ladena A. Walter, case number TRD 24-605, A and B.
Yep, go ahead.
Mr. Smith's case set for a pretrial on
Last Friday. Yeah, it was, Judge. Apparently I'd given the wrong date to my client. I got a hold of her. She immediately said she'd be here today. I just got the urine screen results this morning and the discovery. I would ask that we come back in a couple, 3 weeks, allow me to go over the discovery and the urine test results I just received.
Okay, she's at OVP now?
Yes, she is. I had emailed you her report on May the 10th. She is compliant, and she did graduate from the MAP program at OVP, but she is still continuing with services there, so she is compliant.
Okay. I'll cancel the warrant.
Thank you, Judge.
And I'm looking at 14th of June or later.
Can we do the 21st? She's asked if we could do it the following week.
All right, June 21st, pretrial at 10 o'clock.
Thank you, Judge.
You're welcome.
Thank you. Thank you.
You're welcome.
State of Ohio versus Dana Howard, case number CRB 24-235. Dana Howard.
Your Honor, he was here.
Dana Howard. This is Mr. Stiers' case.
Dana Howard. Yes, sir, right up here.
All right, Mr. Stiers.
I'm sorry, Your Honor.
Yeah, this is your case. He was not here on the 20th, apparently. He's
Oh,
here.
okay, okay.
It's Dana Howard.
Yeah. Your Honor, at this point, he has pled. We were waiting on sentencing for a key that was supposed to be exchanged. Do you have that key with you?
Yes, I do.
Here's the key.
Did he get his stuff? He was supposed to get some stuff.
I don't know if his stuff's been gotten or not.
No, I haven't been able to get a hold of the person that was supposed to go get my stuff.
There's supposed to be a third party who's the go-between on
Well, I
this.
think on the last hearing, there was a person here, wasn't there?
Yeah, that person was here, yeah, that day.
Apparently he lost his phone and got a new number, and I haven't been able to get a hold of him.
Well, part of it's your fault for not being here on the 20th. So how's the state want to proceed on this?
Your Honor, I apologize for not having the file in front of me. I remember the
Okay, well,
key.
you wouldn't because it's not on the docket.
I don't know what else is yet to be done,
You
and I
want to
really
pull your
don't,
file then?
well, I'm going to need to.
Okay, we'll let the prosecutor get their file, we'll recall this later in the docket, you can call.
Thank you.
Mr. Stiers.
State of Ohio versus Daniel L. Cox. Case number CRA 23495, TRC 231103. Roger Smith's case.
Daniel Cox.
Daniel Cox.
He didn't check in yet today, Your Honor.
I think he may be in the jail. He was arrested on fire.
Judge, he is my client. He didn't show up several months ago. I saw him on the jail list.
He's on the jail list,
Okay.
so we'll get to him when we
I'll
get
stand
to
up when he's called, yes.
State of Ohio versus Jessica Price. Case number CRB 11123. Jessica Price.
And Ms. Price is at OBP.
She is. She self-reported here recently. She is due to complete on June the 9th. She is compliant. She did inform me that she had a warrant out of your court, so we just brought her in today to get that taken care of.
So are you finished with Alderson then, or what happened there? We're done?
Yeah.
Okay, well, very good. You're going to be living here now?
I'm trying to.
Okay. Well, I'll work with you to get this done, and I think, I'm glad you're seeking treatment. I think that's a good step. So I'll withdraw the warrant that had been issued on your case and schedule for a month out to get a report as to how you're doing with your treatment. So I'll support that. So your next hearing is June 24th. OVP will give me a report as to how you're doing, and I'll help you as much as I can as long as you get good reports.
Okay, thank you, sir.
Okay. We'll see
Thank
you in
you,
a
Your
month.
Honor.
State of Ohio recalls Elizabeth Hoffman Howard, case number TRC 22164 A and B, TRC 193458 A and B.
All right, Ms. Howard had been called earlier and she wasn't here, but she's here now. How are you?
I'm pretty well, thank you. I had a meeting this morning for work, so I was a little bit late. I do apologize for that, Your Honor.
Okay, thank you. And you're still paying on fines on your last case, so can you make a payment on your fine today?
Does it show where I've done community service?
Yes, I'm showing 6 hours toward your fine.
Oh, so I still have, I thought I was finished for some reason.
I'm not showing that. I mean, if you want to talk to Mr. Major about it, you can.
Okay.
There's some hours that didn't get reported or placed in the computer yet.
Okay.
And I'm showing you still owe fine.
Okay, I can pay $25 because
Okay. Do that. I'll set your next hearing in a month, get it straightened out.
Okay.
If you want to talk to Mr. Major about it, he's out here.
Okay.
And then if it's completed, you don't have to come back, but if it's not completed, you still got to come back for hearings until it's paid off or completed by community service.
Which date did you say? I'm sorry.
June 24th.
June 24th. Thank you. Oh, one more thing, Your Honor, I'm sorry. My driving privileges are, I just happened to look at this. I didn't get pulled over, thank God, but it expires on the 11th of this month. Is there any way you could give me like a few more months?
Let's see.
I don't know how you do that. It says from
Okay, I'll do better than that. I'll send in, because I gave you 2 years. Well, let me make sure I'm saying
1 year.
this right. Let me look at it.
I'm sorry.
Okay, yeah, your suspension is up. Actually, it was suspended until May the 11th of 2024. I'm looking at the entry right now. Your suspension's over. So what you need to do is contact the BMV, say my suspension's up, what I need to do to get my license back.
A huge fine, which I can't afford.
I don't know, they're probably gonna want a reinstatement fee, depends on how much other stuff you got. The more other stuff you've got on there, the more it costs to get them back, so. But it's up to the BMV, it's not up to me, my suspension is over now.
Oh,
I
so you can't.
only suspended you from, until May the 11th, so your suspension's over. You'd rather be suspended?
Yes, yes, just for a little bit longer, especially
Well,
through
sorry,
this
I
weekend.
can't do that, so-
You can't do that, okay.
Now, here's what you're supposed to be able to do now.
Okay.
You probably don't like me telling you. Used to, you had to call, either go to the regional office in Jackson.
Yes.
Or go to the main office in Columbus to talk about reinstatement. Now you're supposed to be able to go into the local office. There's one in Ironton and one in Proctorville, and they're supposed, because they've got the computers right there, they're
Right.
supposed to be able to pull up your information and walk you through what you need to do to get reinstated.
Okay, that's what I will do.
That's what you should do.
Okay. Thank
Okay,
you,
good
Your
luck.
Honor. Have a good day.
Well, let me give you another, yeah, I already told you, June 24th, that's your next
Okay, yeah, you can.
State of Ohio recalls Emily A. Smith, case number CRB 23627.
Okay, have you all seen the results? So we still got stuff to work on. I don't know if she's getting it while she's there or if it's still just hanging out in her system, but
Your Honor, if I may, she left the treatment center and then went to OBP.
I understand that.
So she's,
I didn't do anything between the treatment center and OVP. It should still be in my system from when I went to Mendes a couple of days ago.
Okay, here's what I'm going to do. I'm going to let you stay at OVP, but I want to see you in a week. And we'll keep tabs on you. Where's your kids?
I don't have any.
Oh, I thought you had some kids. Okay. I was thinking of somebody else. All right, May 31st, I'll set you for, well, this is still a pretrial, so Mr. Stratton, I guess we should have waited on him, but he's called in and said he'd be late. I don't think he'd object to this, so I'll let you stay in treatment. I'll see you back on May 31st.
And that means that you have to attend all your groups, you have to do all your sessions, everything the correct way so that you're able to stay at OVP, okay?
Yeah.
Yeah, you gotta do what they tell you to do, when they tell you to do it, how they tell you to do it.
Yeah, I did good for the most part last time I went to OVP. I graduated there.
Okay, well, graduate this time, but let me tell you, Mr. Mintz already said that. We need to look, this is not gonna be the end of it, because you need longer term care. You're gonna be there just to get you started, then you need to go into some kind of longer care program.
I was wondering how
But this will be a good start
the
for you.
fastest way to get this over was.
May 31st is the next hearing.
That's up to him. I don't know the answer to that.
You know,
I was gonna ask you, what would be the fastest way to get this over with? Because
I don't know.
trying to go get to my sister's.
We need to get you
before-
clean, and it's not gonna happen like that.
I know.
You've had a
I'm
long-term problem.
I'm wanting to be further away, like,
Well, I didn't say you couldn't go further away,
That's what we've been
but
working
you're
on.
gonna be at OBP for a while. I just put you on the docket so I can keep checking on you and make sure you're doing what you're supposed to do in a week. I'll see you in a week. And your lawyer will be here then.
okay,
Thank you, Your Honor.
Don't leave, don't run.
okay,
You run, I'm gonna issue a warrant for you.
thank you.
State of Ohio versus Kimberly R. Yates. Your Honor, this is a pretrial. Kimberly R. Yates, case number CRB 2429, is Mr. Thompson's case.
All right, we need Mr. Thompson in the courtroom. We're not calling cases in conference.
Okay, and she also has to make court costs to get dismissed. Your Honor,
Get it on the payment plan.
we had proposed that if she paid the restitution in full today, that we would dismiss the charge upon payment of court costs. I understand she has the money to pay the restitution. I don't know about the court costs.
She needs a little time on that.
Okay, so do we have a figure, the total on the complaints, $336.99?
That's it, Your Honor.
That's what I
You got
remember.
that. The 3 years, okay.
And she has that?
She has that.
But she can't pay the court costs today?
Uh-uh.
Okay. Well, make the restitution payment to the clerk's office, and then let's come back in a month and see if she can pay the court costs then. Is that
Does she have to come
Approximately a
back?
month. I'm sorry.
Does she have to come back if she's paid the cost?
I'll make it that she doesn't have to come back if she pays the court cost. So that's going to be, June 24th.
Okay.
Be dismissed and no appearance required if costs are paid and the restitution paid.
State of Ohio versus Tracy J. McDonald, case number PRC 222574, A, B, C, D, and E.
It's Mr. Smith's case.
It is, Your Honor. I was here last week when he was appearing by video from the jail, and I see that he is now out of jail.
Jail is at the council center.
Yes, sir.
How's that?
It's good. He completes detox today. Plan is to follow up with outpatient with Mahajan.
Okay. What say you, Mr. McDonald? You're on board with all that?
Yeah, I've done signed up with Mahajan. We got the ball rolling on that, but we can't get it started till Wednesday.
Okay. Let's come back in a month.
I'm here the June 21st date, Judge.
Have a
That's
seat.
close
Everybody
enough.
needs to be seated in the courtroom.
June 21st will be the next hearing.
Is this for the,
Pre-trial review.
is this for the failure to appear?
It's for not completing treatment. I mean, you were ordered to complete treatment and you haven't done it. So that's all you got left to do. Complete treatment and you're done.
I don't know if that's possible for me,
Wow.
because it's a lifelong process.
Well, once I get the feel, I'm pretty familiar with you, Mr. McDonald.
Yeah, I know you are.
So what I would say is once I get to the point where I feel like you're on the right path and you're going to continue, you're really committed to this, you're going to keep doing it, then I would say, okay, you don't have to report here anymore. You're done. You're on your own.
Okay.
Because at some point, this has to become your own project. Right now, I don't care if you do it a little bit out of fear because I could put you in jail for not doing it. That's okay. I'm okay with that. But eventually that has to go away and it has to become, I'm doing it for me. I'm doing it because of what it does for me, my family. We all benefit from you being clean and sober. Agree?
Yeah.
Okay.
Yes, sir.
So that's where I want to get to the point where I feel like, I feel like Tracy's really going to do it this time and I don't have to lean on him anymore to make it. Okay? So I'm giving you a month and the longer it goes, I'll space them out even further. And at some point I'll say, you're on your own. Be a man, do it for yourself, do it for your son, do it for all of us. All right, see you on June 21st.
Okay.
State of Ohio versus Cody W. Meade, case number TRC 23152, A, B, and C, TRC 221690, A and B, TRD 222101, A and B.
This is Mr. Smith's case for pretrial.
Judge, my client just indicated he is on a monitor. He does not expect it to be removed, but apparently he's now allowed to work, but like it opened up during his work hours. I don't know if that's something that the court would consider. Is that correct?
I'm sorry.
Is he able to work now?
When it gets to 2.1, so it's probably about 30 days.
That might be premature, Judge. It sounds like we're not to that point yet, but at some point, when he's allowed to work, I'll revisit the matter of like open up during work hours possibly.
Okay, so does he have a job now or is he just wanting to get one?
No, I'm not working right now. I just down-leveled care. I have to get to one more step to be able to work. I'm on high restriction with this monitor. I don't expect to get it off. I'm just trying to get a little bit of leeway to be able to take passes, see the family, and
what's being recommended by the treatment provider?
I think he's fine to take passes. at this point because he's been dropped down to 2.5 level of care. If the court's willing to remove the ankle monitor, I think he would be fine. But that's up to the court, obviously.
Well, it costs us something, when I say us, everybody's paying taxes. It costs us something to keep that on you. We're paying every day for that ankle monitor. So, I do it because I think it helps motivate people to stay in treatment because, if you leave in, it's going to be easy to find you.
Yes, sir.
But the same thing I said to Mr. McDonald applies to you. You're even younger than him. I know him. He's got a few years around the block. You're a young guy. You got a long ways to go, and you could have a very successful life. But you gotta get this substance use stuff under control.
Yes, sir.
So it's got to become for you. You're doing it for you.
Yeah.
That's got to be the most important motivation. You find it in yourself that this is about me. It can start out being about staying out of jail and not getting the stick rather than the carrot, but eventually it's got to become, I'm doing it for Cody Mead because this is the best thing for Cody Mead. Until you get to that point, it doesn't matter. I mean, I can make you do it for a while, but if you never get to the point where you're going to do it for yourself, you're going to relapse at some point.
Yes, sir.
Because you're going to figure out, you're just going to say, well, this is what I want to do. I want to get high. Okay? And that's the most dangerous time when people relapse. So, I don't know, are you to the point where you're self-motivated, that you can do this on your own, you don't need that ankle monitor on you?
For the first time in my life, out of 8 years, I'm taking responsibility for wreckaging. I try to do it for family. I try to do it for myself before. I wasn't to the point of surrendering. And destiny's not, my drugs is not my destiny. And I'm aware and always being rebellious doesn't get me nowhere.
Yeah.
If anything worse, it digs a bigger hole, and I'm not asking for a handout, but a hand up.
Okay. Well, I'm going to take the ankle monitor off. I'm a sucker for a good speech. That was a good one. Now, you can prove me wrong. I can take the ankle monitor off, and then you book it and take off. And I say, well, maybe I need to be more cynical.
Yes, sir. Thank you.
So you go see Mr. Major, he'll make arrangements to take the ankle monitor off of you. Keep doing what you're doing though. You're doing good in treatment, so keep doing it, as you said, for yourself and your family and for your future.
Yes, sir.
And we'll see you in a month, June 24th.
That'll be fine, Judge.
21st.
I can do either one.
You do 24th?
I can do, yes, sir.
June 24th, we'll do that.
Thank you.
Your Honor,
See Mr. Major. Yes.
I want to make sure I know where we are on this. My notes indicated that he had 2 different cases that he's pled to already.
Yes.
So this is sentencing still?
Yeah, we can call it sentencing. I mean, he's already pled. I'm just monitoring his treatment now.
Thank you.
You're right. See Mr. Major.
No, that's really the main thing. It's the time window.
State of Ohio versus Wesley Earls, case number CRA 24276, CRB 24277.
Is Mr. Stiers' cases?
Yes, Your Honor. Good morning. Good morning. I'm not sure what our status is on these. I think we may have needed a re-referral to, I'm just gonna say Court Clinic. I know that's not their name
I know
anymore.
what you're talking
We
about.
know
I know they changed the name, but I don't know what their name is.
I don't know the new name. I think that's probably where things stand at the moment.
Well, here's the problem. He has a felony now.
Yes.
And it's one of those things that's very odd and not quite understandable and why it's this way, but it is the way it is. If the common police court refers in for an evaluation, the state of Ohio pays for the evaluation.
Right.
If a municipal court refers him for evaluation, the municipal court has to pay for the evaluation. So he has a felony. So.
And that was something we had discussed, grand jury was the last couple of days. I don't think in any event, though, that indictments, even what was issued, has not been filed yet. We have this issue coming up in a later case, and we're planning to continue it for a week or so to try to get a result back from grand jury. I don't know if that's where we stand on this one or not.
So you want to just continue it and come back here?
We have, Your Honor, I believe just the one felony, is that right?
That's all I see.
So, and none of the others are associated with that felony, so those would stay here. We can present that felony to the next grand jury.
Oh, I thought it was going to be done on May 22nd.
That's not what we're talking about. It's a different
we had
services, but hang on.
It may have been, okay, I don't know for sure, but we had another case similar to this where we had somebody here that
It's okay.
we were going to go ahead and indict, and we did do that, and I don't know whether we've done this one or not, honestly, but I don't think it has been.
Mr. Steyer.
Well, we're kind of in a holding pattern then. If that's the state's intention, that has to be done in order to get that ball moving in common pleas court. If it hasn't, if it's been done, we can come back in about a week and find out, then they can dismiss these cases if they want to and go forward with that. But part of these aren't cases that can go to the grand jury anyway, because the alleged felony is a completely separate incident from the others.
Is there any way to find out today if there's been an indictment returned?
Yeah, Jasmine says we didn't.
Okay.
I can make sure. Now, I mean, we have to keep some of these cases here anyway. We'll nolly the felony case onto the grand jury today. And then it will, we could come back here
as
in a month.
A practical matter, if there's a finding of incompetence in relation to the felony, I don't think it would be, I certainly wouldn't object, I assume the state wouldn't object if we just used that information here to guide us with what we want to do.
Right.
If there's a finding of competence, then we're back into the issue of whether these are NGRI situations, and if we're going to pursue these here, I'm going to have to...
We can still use the same information you get from common pleas here, I would say.
Yeah,
well, in theory, I mean, since they're separate dates and incidents, I mean, if the court's agreeable with that, that's fine.
Unless the state
The
objects.
state,
That's
okay, because that's a more complicated situation, I feel, but if everyone's on board, everyone's on board. So at this point, if the state wants to nolly the felony to the grand jury and then just set a date back here, I don't think there's much point in setting a date back here prior to the next grand jury, because that's the soonest we're going to know anything. And I would assume that's around the
It'll be a
20th.
month from now.
Well, wasn't the last one May 22nd? Is that,
Yes.
did I dream that, or was that the?
My guess would be this would be the week of the 17th to the 21st of June, but that's a guess, because...
So if we came back June 24th, we should...
Well, I won't be here June 24th, but I will be here June 28th.
So June 28th, Mr. Gill?
That will work, yes.
So CRA 24276 is nolly to the grand jury. Everything else stays here and is set for a pretrial on June 28th, and defendant agrees for, in that time, later time.
I've got like 4 more cases to get called. So, well, I understand, man, I understand. But I just don't know where okay.
And you're going to explain all this to Mr. It's a lot.
If I could just have
There's a lot of legal
one
jargon and rules and
I have
ancient
more
rules
cases
that
to
are being
call,
tossed
so I have
around.
to stand here and keep talking. But if you wait for me in the lobby, I'll come out and talk to you in a couple minutes, okay?
Can I stay outside?
You can, but don't go where I can't see you from the lobby, okay? Stay in front of the doors if you don't mind. Okay, so stay in front of the glass doors.
State of Ohio versus Michael Davis III, case number CRB 24215, CRB 24114, CRB 2490A and B, CRB 2428, CRB 23776.
It's Mr. Steyer's case. This is set for a pretrial. My note from the last one was there would either, this case, at least one of them, would either be set for trial or there would be a plea today.
All right, I think we may have a proposed solution to all this. It's a little bit complicated due to the number of cases. What the state has offered, we are willing to accept, is a reduction of the most recent charge, that should be the highest case number, is the one whose alleged victim is, I'm just looking at this,
Which one do you want, Luke?
I'm looking
Lindsay
for that.
McMillan.
Yes, which I think is 203.
I've got 24-215.
Oh, I'm looking at the wrong case. I'm sorry. Okay, I apologize. That case, there'd be I think it's charged as domestic violence.
Yes.
The alleged victim did not reside in the home. There's no familial relationship. The state has agreed to a reduction in that charge to assault. And in exchange for that plea, we would do a joint recommendation of 30 days in jail suspended and a protective order in favor of the alleged victim and 2 years probation with a protective order as a term of the probation. The other cases, all the cases with Brandy Trailer as an alleged victim would be nollied. This trailer is, hang on, maybe we may have a
come in.
Okay, well, apparently the offer's been withdrawn.
Okay.
Probably need to have a trial, Your Honor.
On the 24-215.
I think we can, I'm gonna add, that he's gonna speak for the state here, but before this isn't what we talked about. But this trailer is here, has repeatedly stated she didn't wish to pursue the charges on which she's the alleged victim. If we're gonna set this thing for trial, I think it would simplify things if the state made a decision if they're going to go ahead and nolly the case that she's the alleged victim on, because that would allow us to concentrate on the one that's actually an issue.
She is here.
I believe.
She's right behind.
Oh, okay, she ducked down, so I didn't see her.
Do you need to speak with her, Mr. Beal?
Well, maybe just to confirm what she said 10 times before.
Okay. All right, Ms. Trailer, it's been represented to the court that in these cases that you are the victim against Mr. Davis, you do not wish those pursued and you wish the state to dismiss them. Is that correct?
Yes, he already went to OVP and done all his, that was on another case. I don't even know why those got brought up today. Those were supposed to have been dropped already.
No, they haven't.
Okay, but you agree with the statement that I made?
Yes.
Is there anything else you want to tell me about this?
No.
All right. So 24-114. Is going to be nolly. She was the claim party in that. 2490. Are you listening?
Yes.
Okay. 2490. Well, he's already pled to the 90B.
Yeah, he's pled guilty to, I think there's a resisting arrest.
Right.
In connection with one of these. That had been pled to in the past.
Right.
And we're not asking for that to be dismissed. We're only the matters that she's directly the victim on.
So the A case, I'm assuming, but I want to check that.
I think the A case is still pending, Your Honor.
That was a violation of protection order.
Your Honor, that's one involving Brandy Trailer, and I don't believe we could prove that case without her help.
So you want that knowledge?
We'd have that knowledge.
2490A is knowledge.
No.
And we've got 2428. That is a domestic violence involving Brandy Trailer from January, so that's going to be knowledge. Then there's 23776. Also domestic violence from December of 2023. There's a lot of smoke here if there's no fire. A lot of smoke. The state's willing to go along with her request, I take it. So all those cases that I've mentioned are going to be nolly. He's already been sentenced on the B case on 2490B. That's when he was ordered to treatment, and he has to find court costs to pay. So we need to set a trial date for 24-215.
Also like to maybe address this issue of the sentence that was imposed on that case involving a resisting arrest. He was ordered to go to treatment. I don't know whether today's a review of that or not to see whether he's actually in treatment.
He was at OVP. Brianna was here, she's up here. That was from April. He was ordered to complete treatment at OVP.
So we'd like to check to see if that's happening. If not, I think we ask the court to
address that issue.
Yes, Your Honor.
Yeah. Okay, let's get a report from OVP as to his treatment progress.
When she gets in here, she'll get it. Just hang tight. We got a lot of moving parts here.
Ms. DeMint, are you able to get, you have a report from us?
Yes, I do.
Thank you.
Oh, you're fine.
If you want to take that one up too. He is compliant with services, Your Honor, and he is a part of the MAP program for his alcohol use disorder. He is taking medication for that as well.
Okay, it says he's compliant with his urine screens and he's been participating in counseling. So it says he's compliant with it. So I'll continue to monitor that. And then we just need to set a trial date on the 24/2/15 case.
So if I'm understanding correctly, just to make sure everything's cleared up, the only case still active is 24/2/15.
And, well, he has a...
Well, but that's post-conviction. Okay. All right.
Yeah, that's what we're talking about. I'll set that for a review. Yeah.
That's what she just said.
Depending on how far out we go.
Your Honor, I'd also like to state what our offer was for him to plead guilty to the domestic violence charge. And we had previously offered
But they hadn't done it yet.
to agree to a 6-month sentence with 5 months suspended.
Okay. You're aware of that?
I was aware of what, I'm sorry, I didn't even hear what he said, I apologize.
6 months with 5 months.
For what?
For the domestic violence charge.
Well, no, he's not guilty of domestic violence, so we'll be rejecting that offer.
She was living there at the time this happened.
We don't believe that's the case. You're here saying she's not, that Randy can't speak for her because she wasn't her guardian and lived there, and now you're saying she's living
She
there.
moved out the day it
So,
happened.
I don't,
She moved out the day it happened, I went and picked her up.
no, I think that's an issue of fact for the case, I guess, at this point. We'll set it for trial.
Absolute record saying I live there.
Yep.
We'll set it for trial.
Yep.
June 24th,
I'm not gonna be here, Your Honor.
June 28th.
I'll be here the 28th.
Is that agreeable to the state and its witnesses?
June the 28th, have a trial? Yes, Your Honor.
I'll set it at noon for a trial.
Please go ahead.
And I'll set 2490B for a review hearing that day. And I'll just set it for noon. We'll look at it for a review. I need a report then as to how he's doing in his treatment at OVP at that same time. Okay, anything else?
Nothing from the defense.
Nothing else from the
If
state.
you want to stick around, I can talk to you a little bit more, because I got a couple more cases.
Trial at noon on 24/2/15. June 28th.
State of Ohio versus Kristen Michelle McAllister, case number CRB 24203.
Mr. Steyer's case set for pretrial.
Your Honor, this is this is a Walmart shoplifting charge. State has tendered an offer, and I've got one. Oh. sorry. The state has tendered an offer of 10 days in jail, suspended, 30 hours community service, a $100 fine, court costs, in order to stay out of Walmart, and 2 years of probation on this matter. We would join in that recommendation as well. She is currently at Southern, she's at Sober Living at Southern Hope, and I would presume the court would require continuation of that treatment as part of this, and we would be agreeable to that as well.
My daddy!
All right, so you agree with what your attorney's represented?
Yes, Your Honor.
Anything you want to say?
No, Your Honor.
Okay, I'll accept your plea. I'll impose a $100 fine and court costs. 30 days in jail suspended on the conditions you complete treatment at Southern Hope. Stay out of Walmart stores. 2 years of level 5 probation. 5 days of community service. Set a review hearing, like June 28th for the first review hearing.
Yes.
At 9 o'clock. She'll need to speak with Mr. Major about her probation before she leaves.
Okay.
Thank you, Your Honor.
So just go back and lay out there and work slow as usual.
Hazelhide versus Jimmy R. Ofield, case number CRB 24225.
She's here, I believe.
Mr. Steyer's case set for pre-trial.
Your Honor, I think the state wanted to just attempt to speak to the alleged victim on this. I think she might be in the lobby.
Shauna Martin, come into court. Shauna Martin.
She's got two autistic sons.
No answer, Your Honor. Shauna Martin.
She was out there just a few moments ago.
Probably outside.
Okay.
Come on.
Your Honor, we've had a chance to speak with Ms. Martin, the alleged victim in this, and she says that they're continuing on a relationship and planning to get married. So they don't have any intention of being separated. She didn't want a protection order before, and she doesn't want one now. And so what we would propose then is a 90-day continuance, make sure there are no further problems, and if there aren't any, then we would be okay with a dismissal with the payment of court costs at that time.
Why do I have to pay? I don't have to, because of the offer they made. Say no. I think I should have paid. Okay. I shouldn't be here.
You want?
What are the court costs now?
125.
So it'd be about 150 after the court point fee.
Well, yeah, whatever, John.
That kind of thing.
You might as
Whatever,
well.
that's fine, let them have their money, that's all, that's about it.
All right, we'll agree with that, Your Honor.
Okay, so I'll set it out 90 days approximately. August 26th. If there's no further problems and the costs have been paid, he doesn't have to appear and the case will be dismissed.
Okay, so if you've already paid on that day, and make sure they tell you you're paid, it's dismissed. It will be dismissed on that day, but you don't have to be here that day, you've already paid.
These cops need to be held accountable for their lives.
I understand that, sir, but it's not what I'm here about. I'm here about your case. All right, thank you, Your Honor.
You're welcome.
Thank you. Ready to go.
State of Ohio versus Carey, resolved. Case number CRB 24275.
This is Tyler Smith's case, set for pre-trial.
All right, so doesn't sound like there's a way to resolve this today. Maybe it just needs to be set for trial. I don't know.
Yeah, we're going to set for trial. Your Honor, that's fine. We're at an impasse, looks like.
Okay. And we're probably into July for trial. July 1st?
That's fine, Your Honor.
July 1st at noon.
Phil, do you want to set up maybe one pre-trial before that, or just discuss?
Yeah.
We can just discuss it between two of us if we can.
Maybe a pre-trial between now and then might help too.
Okay.
I might be able to 24th. Can we do it the 20th of June? June 20th?
That's not a court date.
Oh.
Oh, first.
21st, I'm sorry, yes, 21st is fine.
June 21st for a pre-trial will be the next hearing. Then it'll be set for trial, not resolved.
Great, thank you.
State of Ohio versus Stephen P. Blaney, case number CRA 24224 A and B. Stephen Lehman.
Could you fill one of these out for me? I can't write. No, I don't have time.
Steve Lehman is Attorney Tyler Smith's case. My notes were the case would be dismissed if the complaining party didn't appear today.
That's what I had.
Heather Lister.
That's what we discussed last time.
Heather Lister.
have a recipe in the file for Heather Lister, but I don't show any return of service. I don't know if she was served or not. Recipe for a subpoena.
And Your Honor, we made, looks like a half dozen attempts to reach her by the telephone number that we have. And we also had from her early on a statement that she didn't pursue the charges. So I guess what we'll do is nolly the charge with the right to refile it.
Case will be nollied due to non-cooperation of the complainant party.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
Sorry to bother.
State of Ohio versus Philip D. Henry, case number CRB 24310.
Okay, this is actually an arraignment.
That's the date. That's pretty good, isn't it?
Yes.
All right, sir, you're Philip
Yes.
D. Henry. Mr. Henry, you've just been handed a copy of the charge, which alleges May 20th this year in Rome Township, you knowingly caused or tried to cause physical harm to Madeline Bennett, and that she is either a member of your family or household. That's a domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead?
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
I've already retained counsel.
And who's that?
Mike Eachus.
Okay, I'll put Mr. Eachus down as your counsel. Did he give you any dates when he was available?
No.
Henry not will be pleaded for you. You've already posted a bond. Yes, you posted
Yes.
a bond, so I'm going to continue that. Looking for a pre-trial date. Let's make it 14th of June. June 14th will be your next hearing. That'll be at 10 a.m. here at the court of pre-trial. You need to communicate that with Mr. Eaches, and then if that's not a good date, then he'll ask the court for a continuous, a different date and notify you when you need to be here.
All right,
But as of now, it's June 14th, 10 a.m.
10 a.m.
Yes, sir. Is there any kind of protection order required?
He's trying.
I believe there is, and I would like to ask for it to be amended.
Okay, they just asked for a protection order. How do you, tell me what you wish in the protection order?
If I'm correct, the protection order says not only I can't contact her and that stuff, but it lists my home that I own as her residence and that I can't go there. She was in the process of moving out. She bought a home in Huntington, West Virginia. She was in the process of moving out at the time of the alleged incident. So I'm reasonably sure she has everything she wants now. It's been over 4 days. And I need to get back in my home. You know, there's stuff I need to take care of.
Okay.
We can try to reach her.
Okay, let's let them talk with her, prosecutor I'm talking about, see if that's agreeable, and we'll recall it after they try to talk with her. So we'll recall your case here in a few minutes.
Okay, thanks. Thank you.
You're welcome.
State of Ohio versus Kimberly Litchfield, case number CRB 24309.
Name your Kimberly Litchfield.
Yes, sir.
Ms. Litchfield. Well, it looks like there's only one charge is all I'm seeing, 24309, disorderly conduct. The bond said something about a different charge, but menacing. So is that menacing not going to be followed then? Or?
No.
Okay, the only charge against you, Litchfield, is disorderly conduct. That's a minor misdemeanor, which what that means is the most you can receive is a $150 fine. There's no possible jail time on this. It alleges that you recklessly cause inconvenience, annoyance, alarm to others by engaging in fighting, being turbulent, threatening other persons or their property. As I said, maximum penalty is $150 fine. Do you understand the charge?
Yes,
Do you understand your rights?
yes,
How do you plead?
not guilty.
I can't appoint a lawyer for you because you're not in danger of going to jail, but you can have a lawyer if you want, but you would have to hire your own. What I normally do on these, since they're not jailable, is just set them for a trial. Not
Okay.
come back for pre-trial or anything like that.
Okay,
Mr. Hill.
Well, there's co-defendants, and they're charged also, so maybe they could all be addressed. Brandy Hodge and Charles May.
he's still in the jail, is my understanding.
Okay, let's call Brandy.
State of Ohio
Randy's here.
versus Randy Hodge, case number CRB 24308.
And it looks like this is the same thing. The only charge that was filed was disorderly conduct, minor misdemeanor. That being the case, can we just agree that if they'll not have any further problems for a period of time, we would dismiss these? Because, I mean, there's nothing I can do to them anyway if they're found guilty.
I agree, and that's the reason why I thought they should be maybe addressed together.
Okay.
I don't know why Mr. May is in jail, but he may have something else
Felony
on him.
probation.
Is he going to be discharged with disorderly conduct, or what's his?
He has a parole hold,
Let's see.
probation hold.
He's only charged with disorderly conduct also, so we'll reserve, he can't be here because he's in the jail, we'll see him by teleconference, but here's what, is there some relationship between the two of you?
We all live in the same apartment complex.
Okay. Can we agree to stay away from each other and not get, I don't even know what happened, but obviously something happened because the police come out. In my experience, the police don't just show up at your apartment and start arresting people and filing charges.
As far as her and I
Okay, just listen. The police don't usually show up unless there's a problem. Can we avoid a problem in the future and not get the police involved? Just stay away from each other?
Yeah. Her and I can. The one
Can't
in
stay
jail.
away from him?
No, he's annoyance to the whole neighborhood.
Okay, and what's his relationship to the two of you?
Me, he's my boyfriend.
Okay. Well, I can set them all for a trial if you don't think you can stay away from each
Okay.
other.
Yeah, let's set it for.
You'd rather do that?
Yes.
Okay.
I understand that Mr. May has a parole holder, so I'm sending a message to the parole office to see what their feelings are about this charge and him. I didn't hear the conversation between these two ladies as to whether they can get along.
Well, they don't think they, the one lady doesn't think that it's going to work because of him, that he's
Her and I
going to
can
be a
get
problem.
along. We can get along. We can get along, but him, no.
All right. Would it be okay if I check to see what the status of his parole is? I don't know whether his charge is the only thing holding him on the parole holder, but I'd like to know that.
Okay, ladies, unfortunately, I'm going to make you stay till they investigate that and we find out what's going on with his charges, and then we'll figure out how we can go forward. So,
Okay.
stay have a seat, we'll recall you later in the docket.
Thank you.
State of Ohio versus Caitlin L. Moore, case number CRB 2482, CRA 24243, CRB 24244.
This is Mr. Morford's case set for pre-trial.
Oh, hi, how you doing? Finish this task. They don't give me enough time to do something. Okay. Well, this goes to the grand jury, this burden.
Can you get a change, please?
Did the So, Your Honor, we're in an impasse here. We have a burglary charge that is alleged on around February 6th, and there's an assault charge alleged at this point on February 7th, but those two events, it happened at the same time. I don't know whether it was around the midnight hour or exactly why. It was in the daytime. So that will have to be corrected, but we're going to... did she put up a bond?
She has an OR bond.
Yes.
So she may want to waive to the grand jury, but we're going to take it to the grand jury.
Let's waive.
And then on the other charge is a different date, but it will remain here. If there needs to be a trial on it, we can do that.
So that's CRA 24-243.
Which one is this video of? On which day? What day?
It's a multitude of days over the last few months. One being after court, the last one, sorry.
Okay, so there's going to be a waiver on your hearing on 24-243.
Yes, Your Honor.
We need a waiver for him.
And on the 24 CRB 82, we'll be nolling that to the grand jury.
$24.82?
The assault charge, yeah, 82.
$24.82. Be nolling to the grand jury. So that leaves us with 244 staying here. The menacing charge.
I'm sorry, Your Honor.
The menacing charge is staying here then, that's 24,244?
Yes.
And does it need to be resolved before or after the felonies are dealt with? One felony, does it matter?
I don't think it matters to me, Judge.
It's separate, and we could go forward with it if the defendant wants to.
Is there an offer that the state would put forward on that?
This is an extremely volatile and contentious situation, and I believe that it arises in the middle of a domestic breakup. Either, I don't know, maybe a divorce, I don't know. Children involved, and there's been incidents in West Virginia apparently, and it's hard to weed through this and try to come to an idea about what's appropriate at this point. So that's the reason why we're taking the burglary to the grand jury. We would be willing to try to figure out something here, but there has to be a cost to be paid. But if there's no desire to discuss a resolution, then we'll go that way, we'll go the hard way.
Judge, we have no room to move. It's either dismiss it or let's try. Or let's try. We're fine with the bench trial, Your Honor.
And do you want that tried before the common plea? Like if I set this out for a trial in a month, they're not going to be ready to deal with it. You want to try this before you get common pleas and find out how it's going to be dealt with there, or do you want to have this available for some sort of package? If there's not going to be a package deal, then it doesn't make any sense to wait.
I'm good
to try it.
Go ahead and try it?
Yeah.
Yes, Your Honor.
Okay, so we're looking at, I just set one for July 1st. We're probably looking at after that. The 8th, July 8th.
I'm here then, Judge.
Okay. So that's 244 for trial, July 1st, or I'm sorry, July 8th at noon.
You got the video? All right, look, I ask you a simple question. Is there anybody else that would be?
Thank you, Judge.
Besides yourself? You have videos of it happening? Can you give it to me? If you've been sitting in court, you've seen that video. We're going to talk later, and I'm going to take full attention to it. Okay. Do you know, have you talked to Jasmine? Okay. You know how to get the video to her. Right.
State of Ohio versus Matthew K. Fuller. Case number CRB 2434. Matthew Fuller.
This is Mr. Morfer's case. My notes on this, it would be dismissed today if there have been no further problems in the court costs are paid. Court costs have been paid, and I take it, not hearing otherwise, there's been no further problems.
We haven't heard of any further problems.
Case dismissed.
Thank you, Judge.
You are.
State of Ohio versus Carrie Beth McCoy. Case number CRB 24227.
Mr. Morfer's case, pre-trial.
Yes.
Do you want to accept that? No, he's going to ask you if you got tested. he's gonna ask you to go to be received. He will not take the seat from you in this kind of case unless you have a drug test before. Do you say, but are you going to be clean?
Well, that's good. I mean, she needs some help.
Can we approach Judge, please?
Still want her to do the hearings, so we'll see what it is. After, I want to see what she was 34.
Do you want to take them off? You're from Judge, could you recall this, please?
Case will be recalled later in the docket.
She wants to talk, and I don't want to hold you up.
Sure, thank you.
Sorry.
Have a seat.
State of Ohio versus Stephen Fletcher. State of Ohio versus Stephen Fletcher, case number CRV 23705.
Mr. Stratton's case set for pre-trial.
Good morning, Your Honor.
Good morning. Mr. Stratton, I'll tell you also, Emily Smith was here today.
Yeah.
I didn't realize that she had left Mended Reeds against advice, that she turned herself in to ODP, so they brought her to court today. I just ordered her to continue there and put it on the docket for next Friday, and we'll see how she's doing. So,
Yeah, he already told me all
okay,
about it.
I want to make sure you were aware.
All right.
Angela Pruitt here.
Yes.
Can you come up, please?
No. I'll let her speak with her real quick. Yes. Probably 2 weeks. 2 days on one, 2 days without. That's right. That's our agreement. And of course, there's no institution in the house. Now, I had offered that he could off 5 days in jail, the 60 days in jail, 55 suspended, and he would pay restitution for the cat. I like it. No, we'll sentence you today. And, well, yeah, we'll probably do that. Because we probably want to do like a Friday. I mean, it's probably into the weekend. Or whatever else. Okay. It's like, what not this Friday? Okay.
Approach your honor.
Yes. fine, we can highlight it, it's not gonna be less than 30 days. And I'll decide that.
Because she's usually going back on the restitution on extra response. When they don't have an extra fee on therapy and stuff, whatever, you know. Right. So, what do you think you want to do? Yeah, I'm confident that the court would allow him to do any time on the weekends, correct?
I mean, there are certain cases where I'm not allowed, it has to be consecutive days, this isn't one of those, so.
Right.
But I'll just say this, I mean, you can't break it up like 5, the sheriff does not, because they have to process them in, process them out, it's a lot of extra work for them. If you're talking about 1 or 2 times, maybe okay, but not multiple times.
So, we can take a plea, we'll have to plea for it anyway. And then, yeah, for some. Is that, okay. Your Honor, we'll enter a no contest plea on this matter. I ask that it be set for sentencing.
Okay.
No. It's going
So is that correct, Mr. Fletcher? You want to change your plea to no contest, which means you're not admitting that you're guilty, but you're not denying it either, and you're agreeing that the court can find you guilty without evidence of a trial of guilt or innocence. If I believe what the state says it has as evidence, it's enough for a conviction. Is that what you want to do?
Oh. Yes, that's our discussion. Yeah. Play this one second. Yes, it's complete a recommendation. No more than that. Yes, Your Honor, that's his.
Okay.
Don't let
You agree with that?
Yes, sir.
Okay. So, Mr. Fletcher's entering a no contest plea. Is there a stipulation as, or you want me to hear from?
No, we'll stipulate the elements.
If there's sufficient evidence? All right. So I'll make a finding of guilty. I'm going to delay the sentencing then. We'll have a sentencing hearing, and then I'll decide what the sentence should be, because I understand there's not an agreement as to what the sentence should be between the defendant and the state.
There's an agreement, sort of a minimum maximum on it.
Okay, so it won't be any less than 5 days in jail, and it won't be any more than 30 days in jail, is what I understood.
Well, what we would ask for is 6 months with 5 months suspended.
Okay. So we'll have a sentencing hearing, and ma'am, as the complaining party, you have a right to be here and to give testimony. And I understood that there could be issues of restitution for your out-of-pocket expenses or damages, and I can consider that, but I have to consider it at the sentencing hearing. So if you want me to award that, there has to be testimony and evidence concerning your expenses, and you're allowed to do that at that hearing, but you'll need to be ready to give that evidence to the court on that date. So let's pick a date when we'll do the sentencing hearing, and then I'll make a decision as to what the actual sentence will be.
One other thing I'd like to address too, Your Honor, is that there is one particular video that I think everybody agrees is authentic, and accurate that we just want a stipulation that we're just gonna play that one video. And
That's fine. We'll stipulate to that.
Well,
We'll stipulate to that, but we also need restitution.
stipulate comes into
Oh,
evidence.
sure.
Yeah.
Oh, sure.
And then, I'm sorry, I don't see her name immediately coming up. What is your name now?
My name?
Yes.
Angela Pruitt.
Pruitt. All right, Ms. Pruitt, and you're welcome to be here and give testimony if you wish to give any testimony to the court to consider how you've been impacted and as I said, any out-of-pocket expenses that you have that you want to be awarded. But you need some evidence of that too, like if you have repair bills, or I think there was mentioned there might be vet bills.
Yeah.
I need to see something from the veterinarian's office as to the amount that you're requesting. Okay, let's pick a date as to when to come back for that hearing.
Your Honor, we've been working on this restitution figure for a while, trying to pin it down. I just asked that maybe she can tell us when she would have that available.
Yes, we're gonna get that together immediately.
So maybe,
It's been available, and it was on the disk that I had, but they said there was a problem. I guess someone couldn't access it or access all of them.
okay.
Oh,
Not
the
sure,
bills?
but-
Are the bills on that?
Yeah, there was, I took pictures of them.
Okay.
And also put them on that.
All right,
I
but you
mean, I
still-
have all of them
Okay,
right now. so
well,
we-
can you get those to Jasmine?
Yes.
Okay, so we will have them. Yeah, she gave us a jump drive some time ago, but it was formatted in a way that I couldn't figure out how to open it.
Okay.
So, at the court's convenience.
Yeah. Well, let's consider the parties too. They're both working, I believe. It's going to be a Monday or a Friday.
Friday would be.
Fridays are better, ma'am? Does it matter? Fridays are fine? So let's look for a Friday. Actually, June the 7th is probably the least busy day of the next coming month. After that, we're going into July if you want a day that's not really packed. Okay, so it's June the 7th, enough time to get ready?
July would be better, Your Honor.
Ms. Britt, are you okay with July?
That's fine.
Okay. July 12th? Second Friday in July? Let's just set it at noon, so you don't have to come and sit all day. July 12th at noon for a sentencing hearing.
Right, so get those bills. Right, the papers.
Okay, thank you, Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
State of Ohio versus Stacy Plummer, number PRV 2489.
Thank you, Your Honor.
You're welcome. Mr. Stratton's case set for pre-trial.
Your Honor, we're here on a theft case. We'll plead no contest to that charge. I know that the state, the courts usually does testing, so.
All right, is it correct, Ms. Plummer, you want to change your plea to guilty on the theft offense? Is that correct, ma'am? All right, well, I'm going to order that you do a urine screen before I send you, so if you'll go out in the lobby, they'll direct you where you need to go to get that done, and when I get the results, I'll Heading back for sentencing.
State of Ohio, Joseph W. Rice, case number CRB 2426.
Joseph Rice is Mr. Stratton's case set for pre-trial.
Your Honor, I believe the state's going to move to dismiss this case today. I believe that's part of the agreement.
It was, and there have been no further problems. I also see something about RRS too. I don't know whether he was seeking some kind of treatment.
Yeah, he did anger management.
Yes.
And he completed that, so. He had that completed a lot. Did you complete that?
I've never gotten my certificate.
Oh, okay. But it is completed.
Yeah, I'm going every day. I'm doing everything that's supposed to get in.
But he's going to RRS.
It was Bethesda, I believe, is the report I had.
Okay.
Actually, I have marked down Bethesda too, but I was,
Well, my notes are not always perfect. Strive for that.
So how's the state going to proceed on
I
this?
guess we'd like to make sure that he has followed through with the Bethesda program.
I got a report, but it doesn't say he was completed, it just said he was there participating.
What's the date on that report, Your Honor?
March 11th through March 17th.
I wonder if we could get it current.
he has not received a certificate of completion yet, Your Honor, but I believe he's done with everything.
Yeah, I've done everything I can do. I'm supposed to do.
Your Honor, he is compliant with the Taylor's doing action.
All right. Dismissed then, or do you want the cost?
We do want the cost paid.
Can you pay the cost?
Yes, what does it cost me?
130?
150 would be 150. Court assigned counsel fee. 150 total.
150.
I can do that.
Yeah, go do that.
Be dismissed on payment of costs.
All right.
See the clerk.
Go see the clerk, get that paid, and it's dismissed.
Thank you, sir.
All right.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Perry S. Schaefer, case number CRB 24-145.
Mr. Stratton's case set for pre-trial.
I know.
I should have,
Your Honor, I asked that we set this for another pretrial, and it's my fault. There was a video available in this case, and I don't know where, I misplaced it. So I've been looking for it for the past couple of days and haven't been able to find it, so I need to have the prosecutor give me another copy.
Okay.
I'm going to charge you for this one.
I did want to continue.
Come back June 7th?
Yeah, June 7th is fine.
June 7th.
What time?
Missy.
10 o'clock. Yeah, I'm writing it down here. All right, very good. Okay, hey, I want to give you this. This is a copy of the entire discussion. Just not the video. All right.
State of Ohio versus Christopher Blevins, case number CRB 2286, CRC 21595A and B, CRA 21162, CRB 19439.
Your
All
Honor,
right,
Chris,
Stratton's case.
and he is compliant with OVP outpatient in Huntington. He's still working, and he did provide a urine screen today that was sufficient.
Okay. Pay anything on your fines and costs?
Yeah.
You got community service too.
He does, I do have a letter here from Facing Hunger Food Bank where he's done some community service, Your Honor.
You would be a good candidate to come out tomorrow.
Yeah, Your Honor, he's turned in 2 hours.
Okay. We need you here, will you be here tomorrow at 7:30 a.m.?
I work tomorrow.
Where you work?
Savita Behavioral Health. I work in a residential facility taking care of people with mental handicaps. Normally I work nights, but I picked up this shift tomorrow.
What time you go in?
I go in, I work 8 to 8.
Okay.
Are you paying anything on your fines today?
Yeah, I'm gonna pay $50.
Got to see the clerk.
Your Honor, how much of community service does he have left?
Initially, there was 30 hours. I don't know the tax credit, what's left. In this one case, are we ready to go ahead and resolve it? The 2286 is the only open case he still has. That was,
If he's on for pretrial, it may not show in that folder. He can check with us in probation, we're gonna let him know.
looks like a domestic.
I believe that we were going,
Domestic violence, yeah.
we were going through this, and once we got everything completed, I believe that was going to be
Be
dismissed.
dismissed?
Yes.
Yeah, okay. All right, we'll leave it hanging. June 24th?
Yes, Your Honor.
Thank you, Your Honor.
Go ahead.
You're welcome.
Come back. Get it paid today.
All right.
State of Ohio versus Christopher W. Shank, case number CRB 2433. Christopher Shank.
Christopher Shank. This case, he was told would be dismissed if he paid the court costs and there was no further problems. Costs have not been paid. He hasn't appeared. So I'll issue a warrant.
State of Ohio versus Larry Tickner, case number CRB 24249.
This case is set for a pretrial. And Mr. Tickner, do you have a lawyer?
Yes.
Who's your lawyer? Who's your lawyer? You said you had a lawyer?
I didn't, I couldn't afford one, sir.
Okay.
I'm just representing myself.
You want me to consider you for a court-appointed attorney?
No, I'll just plead guilty to the charges.
Okay, well, you want me, you didn't answer my question though. Do you want me to consider you for a court-appointed lawyer? I have to ask you about your income.
No.
No? You want to change your plea to guilty?
Yeah.
Do you realize that means you're admitting the charge is true?
No.
Yeah, if you enter a guilty plea, you're saying, this charge is true. I'm admitting it. It's true. You understand that? That's what a guilty plea means. You're charged with having a weapon while intoxicated. That is the charge.
Right. Well, I mean, I did have 3 or 4 drinks that day, but I wasn't, like totally intoxicated. That's why I pleaded not guilty the first time.
Well, then maybe you need a lawyer. This is a,
Well, yes.
This is a serious charge. Do you work?
I didn't hear you, sir.
Do you work?
Yes.
What do you do?
I work maintenance
Where?
at McDonald's.
Okay, are you paid by the hour?
Yes.
How much per hour?
I called 17 the last time, but I don't make that much.
How many hours a week?
I
40? Are you working full-time?
I work 4 days a week.
How many
8 hours a day,
Okay, 32 hours.
yeah.
Okay, I think you're eligible for court-appointed lawyer then. Mr. Morford, I'll appoint you to represent Mr. Tickler. He has a using a weapon while intoxicated charge. Let's set it for a pretrial. June 14th.
That's good with me, Judge.
June 14 will be the pretrial at 10 o'clock.
Yes. My phone number?
Thank you, Judge.
You're welcome.
State of Ohio versus Jared Nolan, case number CRB 24-160 A and B.
Okay, Mr. Smith is the attorney, Roger Smith, set for pretrial.
Hey, Judge, I spoke with my client, I spoke with Mr. Hill. The state has a proposed recommendation that my client is interested in changes pleaded guilty, which would be on both the assault charges, 30 days in the county jail, suspended. Talk about a fine.
We didn't discuss the fine.
We didn't discuss a fine, leave that up to the court judge, court cost, and whatever level of probation. And he lives in Gallia County, so if it's community service, I would hope that he could do that in Gallia County, not have to travel to Lawrence County.
Same affidavit from two different people about the event.
Correct, Judge.
All right, Mr. Nolan, anything you wish to say?
No, sir.
How do you pay for medical services? Do you have a medical card or
Not right now.
insurance?
I applied for it through my work, so,
You have health insurance then, or
yeah.
where do you work?
I switched to Asplin Tree Service.
Okay. And you live in Gallup?
Yes, sir.
Or does they say Gallup Police?
Yes, sir.
All right. Mr. Hill?
Well, Your Honor, just so that the court's aware, both of the victims were okay with the suspended jail sentence. Mr. Kuhn said that at the time, had Mr. Nolan apologized to him, he wouldn't have even wanted to make a complaint about it. So we're satisfied with this, and I don't know what, you bringing up the issue of his pay source, that could be an issue that needs to be addressed as well. As far as
Well, it appears, just from reading the affidavit, he was pretty intoxicated at the time this happened, so. But since he's out of county and doesn't have, looks like a very amenable way of getting an assessment, I'm not gonna, and nobody's asking for it, so I won't order it at this point.
and Your Honor, we want no contact orders also.
That will not be a problem.
All right. As to each case, I'll impose a $200 fine. One court cost since they arose out of the same incident. 30 days in jail suspended as to each. Order to stay away from, on the A case, it was Jacob Russell. B case is Nick Kuhn. Level 5 probation for 2 years. Review hearing November 22nd. At 9 o'clock.
You say November 27th, Judge?
I'm sorry.
November 27th?
November 22nd.
22nd.
22 at 9 a.m. You'll need to see Mr. Major before he leaves today.
Thank you, Judge.
You're welcome.
This is your protection. You're going to stay away from these fellas. So it's not you don't know them anyway.
I know.
So you'll get a copy for that.
So I signed it.
You signed it, just the one spot.
Yeah.
Then if you're away from home, you should get a copy, bring it to you. You're going to see probation anyway, which is just to the left by the
What's the
lobby.
next day?
24th. May 24th. You see, probation should bring it to you. Take care, yeah. That should be your.
State of Ohio recalls Philip Henry, case number CRB 24310.
Okay, this was recalled on the issue of protection orders. My understanding, I've been told that you did get in touch with the complaining party. She does want a protection order. And, the issue is she getting out of the house.
Yes, Your Honor. She has moved out of the residence and is in Huntington, West Virginia now, so he can return back home.
Okay. There will be a protection order. You stay away from her, but you'll have to stay away from the residence that's in Ohio, because that's yours. We'll keep the same date, June 14th is your next hearing at 10 o'clock.
All right, thank you.
Yes, sir. Your bonds continue.
Thank you.
Sir.
State of Ohio versus Natalie Stapleton, case number CRB 24312.
Take the file.
He was right here.
Natalie Stapleton is here.
Yes. Let me get this file. Everybody's waiting on theirs.
And Ms. Stapleton has alleged that at Fayette Township on May 9th, you purposely tried to defraud Walmart of property without their consent. That's a theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
No.
Well, it says you tried to shoplift something from Walmart. That's the charge against you. Do you understand that? Yes?
Can I have a lawyer?
Answer my question. Do you understand the charge?
I don't understand the charge.
I'm sorry?
I don't understand the charge.
Well, it's pretty simple. They're saying you took something without paying for it or tried to at the Walmart. Do you understand that?
Yes, I understand that.
The maximum penalty is 6 months in jail, $1,000 fine. And here. How do you wish to plead to that charge?
Guilty.
Okay, well, I thought you told me you wanted a lawyer.
What is that?
Do you want a lawyer? If you want a lawyer, you should enter a not guilty.
I want a lawyer, yeah.
Okay, well, I'm going to enter a not guilty plea for you. Do you have a job?
I don't at the moment. I'm a stay-at-home mom. I have 2 kids.
And no income? Is there any income in the,
I get child support.
how much is that?
$544, and my parents was going to help me pay like a fine or the ticket
Okay. $544, how often?
once every month.
Okay, you're eligible for court-appointed attorney then. Mr. Smith, Tyler Smith, I'll appoint you to represent her. I'm entering a not guilty plea for you. And she can sign a signature bond of $1,000. June 14th is the next hearing.
It's fine, Your Honor.
June 14th will be the next hearing, 10 o'clock for a pretrial.
All right, thank you.
You're welcome.
State of Ohio versus Stephen Baldwin, case number CRA 24248.
This is Mr. Steyer's case. Stephen Baldwin, preliminary hearing.
Your Honor, Mr. Baldwin is at Shawnee Counseling Center. He has requested that he be allowed to transfer to, what's it called? Regal. To Regal. Regal has a representative here today. I've spoken to them. They are willing, we're here now, I'm sorry. Spoken to them. They are willing to take him.
He was supposed to get amended reads.
I know, I can tell you what happened. I needed to be hospitalized, and they weren't adequate for, at the time, when I was having mental illness issues. They had to send me
I sent you to amended reads.
They had to send me to ARC, and then amended reads said they weren't able to take me back, so then I ended up going to Portsmouth because there was the only bed open. But I have family down here and more support, and they can't really get to, I can't really.
He's unable to see them for visits in Portsmouth. They would be able to see him at Regal. So Regal is here. They are willing to take him. So I'm going to
approach.
I'm sorry?
I want counsel to approach. It's my understanding from our discussion that Mr. Baldwin has been indicted, so his case is going to be going to the Common Police Court pretty soon, sounds like.
That's my understanding, Your Honor.
So I'm going to just to make sure that does happen. Let's continue it for a week to the 31st. I'm not willing to make a change because he's going to Common Police. I'll let them make the call on that. It's going to be one of the Common Police judges having it shortly. Ankle monitor remains in effect. Here, the 31st, it may already be filed in Common Police by then. If it is, then that will be the last hearing here in this court.
Thank you.
Okay.
Thank you, Your Honor. Okay, I'll see you next week.
Thank you.
State of Ohio versus Nathan C. Beaver, case number CRA 21257.
Mr. Steyer's case. Yeah, I see the report.
This is a positive report, Your Honor. Mr. Beaver had inquired whether we are reaching the point where the court would be ready to wrap this case up. I told him I would raise that issue this morning, well, afternoon.
He just came back, this is an old case, but he only came back to this court in January of this year. So we're about 4 months in. And it was filed as a felony. How's the state want to proceed?
Is he being monitored by QRT also?
I don't have a record for that, no. I mean, if you would want, Megan's not here, if that's something you'd want to have her consider.
I guess what I'm thinking is, and I don't know the answer to everything that I'm wondering here, but
I'm not 100% certain of this, but my memory is he was looked at for QRT, but the reporting requirement would be difficult due to his location.
Yeah, they make him show up in Ireland.
Yeah.
Yeah, and he lives in Gallipolis, I believe. So that would, he'd have to be in Ironton twice a month, and that's be pretty burdensome.
I guess I'd want to know from OVP what their expectations were for the next short time period as far as how much longer that they would recommend him treatment.
Well, that's up to his treatment team at the Gallipolis location. I can definitely find that out.
If you could find that out, that would help us to figure out.
If we want to come back and I can discuss that with them and see what their recommendations are.
Yeah, we're not really that, compared to what most cases last, this is pretty short.
Right.
I guess my only thought was I didn't know what had happened since 2020 up to this point as far as whether he'd had other attempts at recovery or had been, so that was my...
He wasn't before the court for a long time. And I don't really have an explanation why that happened. It was filed April of 2021. They didn't appear before the court until January of 2024.
The affidavit that accompanied this, very minimal as far as it was one of the local police that arrested him. I don't know whether they let him go and then he was indicted and then he wasn't arrested. It was Chesapeake Police, so I just don't know.
He indicates he wasn't aware he had the warrant until he found out about it here recently, which, considering how it came to us, that's not unbelievable, Your Honor.
So that was just in my mind. I think we'd like to have something from OVP to see what his progress is.
Okay, let's come back in July.
I'm available the 8th, Your Honor.
July 8th will be the next hearing.
Thank you, Your Honor.
We'll look at whether it should be concluded then or not.
Appreciate it.
Thank you, Your
Thank you.
Honor.
And if it had a report directed to that issue, Mr. Manager, say he needs longer,
I'll get that.
doesn't, or he's concluded, then I would like to know that.
Okay. Thank you, Your Honor.
Your Honor, we're ready to go to Lawrence County Jail.
Okay, we have some hearings at the jail to do now.
State of Ohio versus John Cooper Ryder at the Lawrence County Jail, case number CRA 24311, and Daniel Cox is on deck.
John Cooper Ryder, is that you, sir? Okay, your audio is turned off, so the deputy could, it's probably on your headset, it needs to be turned on. Okay, let's try it again.
Can you hear me now, Your Honor?
I can, yes, thank you. All right, Mr. Cooper Ryder, I'm Judge Capper at Lawrence County Municipal Court in Chesapeake. This is where your arraignment is taking place. You are appearing in the court on a monitor now. Everything's being recorded. If you say something, it could be used against you. You have a right to have an attorney, and you have a right to remain silent. You don't have to say anything. You have a right to have bail and to make the state prove this charge beyond a reasonable doubt. You understand those things?
Yes, Your Honor.
The charge against you is domestic violence. It's filed as a felony 4. The state's alleging that at Fayette Township on May 21st, you not only caused or tried to cause physical harm to Tiffany Phillips, and that Tiffany's either a member of your family or lives in your household. So that's why it's called domestic violence. This particular version of it carries a maximum penalty of 18 months in jail and a $5,000 fine. Do you understand the charge against you?
Yes, Your Honor.
And you understand the rights I explained to you?
Yes, Your Honor.
Do you have the money to hire a lawyer?
No, I do not, Your Honor.
Do you have a job?
No, I did up until I got incarcerated.
What did you do?
I worked at Arby's in South Point.
Okay, I'm going to appoint a lawyer for you then. Roger Smith will be your attorney. He's here and he's heard your arraignment. When did you come into the jail, sir?
I came in on Tuesday night.
Yeah, that was the 21st, so the day of the we can do the preliminary on the 31st if you're available.
That would be better for me, Judge. I am here the 31st. I have less cases on Friday than Tuesday.
Okay, May 31st will be your next hearing. What's the state's position on bond for Mr. Cooper Ryder?
Your Honor, in reading the officer's report, first of all, there were law enforcement officers who actually witnessed this. And sounds like a pretty bad situation. The officer says each time he struck her, I could hear a thud and her scream. So he was actively hitting her at the time when the police arrived. We'd asked for a $10,000 cash or surety bond. It's a felony case too.
Judge, I will call in the event he's able to make bond. I'll ask him to be recalled. Otherwise, we'll be prepared to go forward next Friday. But I will call down to jail before I leave to discuss bond with him.
All right, I'll set the bond for now at $10,000 cash or surety with a protection order. So that what that means, Mr. Cooper Ryder, is if you do make bond and get out of jail, you're ordered not to go around or contact Tiffany Phillips. Is that right? Do you understand that? You got another place you can go?
I do. I just graduated treatment at Ryder Days. They wanted to take me back based on the fact that we grew lapse that night. But obviously, that's not a situation we can deal with right now.
Well, it may be. Mr. Smith
I
can
will
talk
talk
to
to
you
him.
about that.
That could be.
But for now, I'll set your next hearing for a preliminary hearing on 1 week from today, May 31st, with a cash or surety bond of $10,000 in order to stay away from Ms. Phillips.
Okay.
Your lawyer's going to call down and talk to you here shortly.
Okay.
All right, that's all. Thank you, sir.
State of Ohio versus Daniel L. Cox, case number CRC 231103, CRA 23495, and CRA 08435. Corey Easton is on deck.
And this happens to be your case?
It does, Judge. I haven't seen Mr. Cox for a few months. I do not have his file, but I do remember the case. He's probably here on a failure to appear, I would assume.
It is for Wesley got a pretrial February 9th, and it's on an OVI. Wesley did show up, got a warrant, and it looks like he got arrested on the warrant, so he's in jail now. So I'll let you talk to him, but unless there's some good explanation, I'm going to order that he had an OR bond, that be forfeited, $2,000 forfeited, and that he post a new bond of $2,000 cash and surety. And then I'll put him on the docket for May 31st also.
And I will call and speak with him when I speak with the other gentleman.
For pretrial, May 31st. Okay, that's all. Mr. Smith, you want the first call?
State of Ohio versus Corey Easton, case number CRB 24-247, CRB 24-222.
Mr. Stratton's case, Corey Easton.
Well, she's got Ironton cases also. We approach her.
Yes.
Yeah, right.
Our meeting. 10,000 here. All right, next hearing for Ms. Easton will be June 7th for pretrial in both cases.
All right, thank you.
You're welcome.
State of Ohio versus Eric Hanna, case number CRA 24304. Johnny Lewis is on deck.
Hello, Your Honor. Attorney Matthew Weisskopf entering an appearance on behalf of Eric Hanna in this case. Your Honor, we would waive reading of his charges and are not guilty plea to the charge or charges. Ask that the matter be set for a preliminary hearing and ask to be held on bond.
Okay. I guess we should probably get him on the screen.
Oh, sorry, Judge. I didn't even notice he wasn't there.
Yeah. So just looked up, so there's nobody here. There's a special prosecutor on this?
There will be.
Well, it's signed by William Wall, special prosecutor. No relation to Judge Walton.
Well, Yeah, it's his son, probably.
Oh, okay.
I didn't know he was gonna be.
I didn't even know he was a lawyer.
Well, he is. He's been in Columbus his whole
Yeah,
career.
out of Columbus.
May we approach her?
Yeah. Okay, sure. Is Mr. Warren reachable? Well, just be signed. And style this, Mr. Russell. Okay, well, and maybe you could have a conversation. He wants to get on here by teleconference or whatever. All right, Mr. Hanna, your lawyer is here. Mr. Weisskopf has entered an appearance for you. There's a special prosecutor. We're going to try to get in touch with the special prosecutor to get input on bond. So we'll recall you later in the docket after that happens, or when it happens. You may appear by teleconference also.
State of Ohio versus Johnny Lewis, case number CRB 24314, A and B, and Derek Lockhart is on deck.
All right, so we need Johnny Lewis. And sir, you're Johnny Lewis.
Yes, sir.
I'm Judge Kapler at Lawrence County Municipal Court in Chesapeake. This is where your hearing is taking place. You're appearing here on a television monitor. It's all being recorded. You have a right to remain silent. You don't have to say anything, but if you do make statements, it's on the record. It can be used against you. You have a right to have an attorney appointed if you can't afford one, to have bail, to make the state prove these charges beyond a reasonable doubt. Do you understand those things?
Yes, Your Honor.
So I'm going to go over the charges with you now so that you understand them. You don't have to agree with them, but you need to understand what you're charged with. The first charge is felonious assault. It alleges, this is 315A, is the case number. It alleges on May 22nd in Union Township, you knowingly caused or tried to cause physical harm to Patrick Neville by means of a deadly weapon. That's a first-degree felony, carries a maximum penalty of 10 years in jail and $20,000 fine. 315B, I'm sorry?
Is that one of the cops or something?
I don't know. It's somebody, by the name of Patrick Neville.
I don't even know where this, I don't understand where this is coming from, this background. I ain't got a clue about this. Never met a Patrick Neville. I'm clueless to who you're talking about right now, but ain't opposed.
Where's Union Township at, Mr. Captain?
Chesapeake, basically.
I'm not guilty on this one for sure. I know that. I don't even know what to talk about.
Okay, I'm looking at the affidavit. It talks about running over spike strips and being arrested that way, but to tell you the truth, the affidavit doesn't really say anything about the felonious assault, actually, unless it's on another charge here. It doesn't on the second one. Yeah, there's really nothing in the affidavit about a felonious assault. But anyway, they have to prove those charges. Maybe they can't prove them. I'm just telling you what they've alleged against you. Felonious assault is the first charge. The second one is failure to comply with the order or signal of a police officer, same date and time. And the third offense is obstructing justice. And this one alleges that you struck a police dog causing physical harm to that dog. So that's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine.
All the affidavits are the same thing.
Do you have the money to hire a lawyer?
No, sir.
Are you working?
I was prior to this, Mr. Capper, and when all this went down, my boss wasn't working anymore.
Where were you working?
River Cities, Rhode Island, South Point.
What were you doing there?
I dealt with cards, sir.
Working on them or what?
I know I dealt with cards like poker.
Oh, I thought you said worked on something about cards, dealt with cards. Cards, C-A-R-D-S.
Yeah, I was the floor manager down there, and when all this stuff started taking place, and I started running.
There's legal gambling in Lawrence County? That's news to me. I didn't know that.
Yes, there is, Your Honor.
Okay. How much were you paid doing that?
Did we file?
It was like, I made like an average of anywhere from $20 to $60 an hour. Like I said, I haven't worked since all this happened. There's any way you can arrange for me to get back to work, maybe house arrest or something, do court, it helped.
How many hours a week were you working?
7 days a week, usually.
That's pretty good money. If you're making $60 an hour.
Well, I've been on the run for about 3 weeks. It's equaled up to nothing as of now, but it was, I don't know, this is bogus charges for me that started this mess, and I'm not even hearing the charges that the actual target court, you're not even ready to this.
Okay. I'm going to go ahead and appoint a lawyer for you. I'll appoint Tyler Smith provisionally, since he's not working. What's the state's position on bond?
Your Honor, I don't have an explanation for why there's a narrative, there's an affidavit that describes the failure to comply. And I think that fits pretty good. I don't know these other two charges. We've gotten the same affidavit for all of them. I think there's been a mistake somewhere down the line. But as to the third-degree felony charge, it was serious enough on its own, so we'd asked for a $5,000 cash or surety bond.
Okay, I'll set that at $5,000 cash or surety.
So that'll be 500 with 10%, Mr. Captain?
Usually, yes, sir. But with a bail bondsman. You want to talk to a bail bondsman?
Yes. My woman's in the courtroom. She's saying yes.
Okay. Lucky man.
Well, Mr. Capper, I've tried to change, I know you see me a lot, but I've tried to change my life and turn it around. And just a small incident threw me sideways. I'm glad it ends here. Work out worse.
When do you want to come back, Mr. Smith? Next Friday?
That's fine, Your Honor.
All right, I'm setting your next hearing for a week from today, May 31st, for a preliminary hearing, 10 o'clock.
Yeah, those.
So next Friday is your next hearing, 10 o'clock.
Thank you, Mr. Capper.
You're welcome. And you'll let Mr. Sowers know?
So, look.
State of Ohio versus Derek Lockhart, case number CRB 24313, and Charles May is on that.
Okay.
Sir, are you Derek Lockhart? You are Derek Lockhart?
Yes, sir.
Mr. Lockhart, I'm Judge Capper. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to have bail and to make the state prove this charge beyond a reasonable doubt. You understand those things?
Yes, sir.
You're charged with domestic violence. It's alleged that on May 21st of this year, by threat of force, you caused Chelsea Lockhart to believe you would cause imminent physical harm to her or a member of her family. That's a 4th degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. You understand this charge?
Yes, sir.
How do you wish to plead to it?
No contest.
No contest means you don't want to fight it, you agree, I can find you guilty if I think the state has enough evidence that they can convict you with that. And you're agreeing to do this without a trial and a lawyer.
Yes, sir.
Is that what you want to do?
Yes, sir.
Okay, have you got a report on it, Mr. Hugh?
I do. This is the statement from Deputy Shope from Lawrence County Sheriff's Office. On May 21st, I was dispatched to 38 Private Drive 3, Township Road 1128. That's in Union Township. When arriving, I seen a female standing outside. When getting out to talk to the female, who was later identified as Chelsea Lockhart, when talking to Chelsea, she first said everything was verbal and nothing had happened. I then went and talked to the male, who was Derek Lockhart. When talking to Derek, he had said the same thing about everything being verbal. I had then went back down where Chelsea started crying and said he threatened to punch me in front of the kids. I then asked her if anything else had happened, where Chelsea would state that Derek got upset because the kids were taking her side in an argument and flipped the table. When going to place Derek under arrest, Derek had tensed up on me and didn't move his arms for me to place the cuffs on him. After talking to Derek and reasoning with him, Derek calmed down and let me place the cuffs on him. I then escorted Derek to the cruiser, where he refused to go inside the cruiser. Derek began cussing and screaming to speak to someone above me, or he wasn't getting in the cruiser. I then had to place his legs in the car, where he would be brought to the Lawrence County Jail.
Okay, Mr. Lockhart, anything you want to say?
Your Honor, I wasn't trying to fight the problem. I was going to speak to somebody, but I didn't hit her. I don't even remember correctly, Your Honor, honestly.
What's the state's position on sentencing?
I'd like to see if Chelsea Lockhart is here. I guess the most immediate thing would be, we'd want to make sure that until we know what her feelings are, that we wouldn't want there to be no contact between them. And we would need to come back maybe for sentencing at a later date.
Your Honor,
Yes.
is there any possible way that I could go work out? My daughter's first birthday is Saturday or Sunday.
Okay. Here's what I'm going to do. Do you have a place where you can go stay other than with Chelsea?
Yes, sir.
Where would that be?
Down at my kid's grandma.
Judge, we can try to get her on the phone and see.
Okay, they're going to try to get her on the phone today, so let's do that. I'll have you back. They'll try to call her up, see what she wants. I get some input from her, then maybe we can wrap it up today. If not, I may have to delay the sentencing until we can talk with her. So we'll have you back on the screen after the prosecutor tried to reach out.
Okay, sir.
Okay, we'll see you in a few minutes.
Thank you.
You're welcome.
State of Ohio versus Charles May, case number CRB 24307.
Charles May. They're still in court. Thank you. Okay, we need Charles May. And this is the one the state was going to try to find if they're on a parole violation or something like that as a holder.
Yes, and I sent a message to Matt Stonebeck a long time ago, and he said, give me just a minute at 11 o'clock, and he hasn't answered me back. So, I'm going to go out on a limb and assume that if they got a parole holder on him, that it's probably more than just this. And if they keep him, it'll be because of other reasons. Here's somebody with some brains.
There's 3 minor misdemeanor disabilities, and they both. What is the big problem? It was Charles May. She got some history. Maybe when they reach out to Todd Smith.
Okay.
I think Cots is actually PO.
Okay.
So let me reach out.
Your Honor, Detective Lehman's going to reach out to Todd Smith, who's probably his actual parole officer.
Okay. Mr. May, I'm going to recall you. We're checking with your probation officer to see if this charge affects your parole or probation. So I think that would be good information to know before we do the arraignment.
Okay.
So I'll recall you after we find that out.
Okay.
Okay.
State of Ohio versus Timothy Summers, case number CRB 23749.
Your Honor, last time we were here on arraignment, I believe, Mr. Summers we agreed to send him to TCC on an ankle monitor. However, he's being held on a $25,000 cash and surety bond out of common police court. His next court hearing date is June 12th, so I ask that we just set this after that.
Okay.
We actually asked for a subpoena to be issued for Bethany Camelon. And I don't know whether that was served or not. Is Bethany Camelon here?
Bethany's in treatment.
Well, I did get a return that says, return to court no longer at this address on the
She's
subpoena for her.
She's in residential care with Bethesda.
Okay.
All right,
That's
so
Bethesda.
we're not opposed to continuing this case then.
Yeah, I think we'll know more after the resolution of his felony cases.
All right, Mr. Summers, your lawyer's here, Mr. Stratton. He says you've got a case in common pleas that's set for June 12th.
Yes.
So I'm going to set your case here for June 14th, because that day we'll know what common pleas is done with your case. Today we don't know, and they have a holder on you.
Okay.
All right, thank you. June 14th will be your next case, next court date in this court.
Yes.
10 o'clock. So if you get out, if they release you, you have to get yourself to court on that date, June 14th. But obviously, you're still in the jail. I'll see you by teleconference.
Okay.
You're welcome.
State of Ohio versus Michael Tilley Jr., case number CRA 23165.
Mr. Steyer's case, preliminary hearing.
Your Honor, based on my discussion, let's get on the thing. He's here, right there. Your Honor, based on my discussions with the state intends to nolly this matter to the grand jury. We have no objection to that.
Okay.
Which one is this?
Tilly.
Does that mean he's going to be getting out, or is he got a holder on?
I don't know if he has a holder or not. There is an issue in another county, but we're not certain whether a holder's been placed on him. But if not, he would get out. If so, he would be free to deal with that issue. As far as I'm aware, no Rule 4 proceedings have been implemented.
Yeah.
Okay. And we have Ms. Osborne, and you don't want to pursue the charge, is that right?
Not really.
So, based upon that, we would nolly the charge.
Is 23-165 here allowed?
Yes.
Okay. All right, Mr. Tilley, the charge in this court is going to be dismissed.
Sir, can I please apologize to you for the way I acted the last time I was in front of you? I know I'm not a trouble with you anymore, but I did disrespect you, and I want to apologize for that. That's all.
All right, thank you, sir. The case here is dismissed.
Thank you, sir.
Thank you.
The State of Ohio recalls Derek Lockhart to Lawrence County Jail, case number CRB 24313.
This was recalled. We were trying to get a hold of complaining person. Right, Derek Lockhart's back on the monitor, and state was going to try to get a hold of the complaining party to get her input.
And we did. And I guess I'd prefer to have you just read what I've got here as opposed to.
Okay.
Something Jack needs to handle.
I don't know. One is here.
Okay. Someone from the prosecutor's office spoke to Chelsea. She wants you to come home, but she wants you to get help with your alcohol. And that's a part of the condition, that if you would go to some counseling for alcohol issues, come home and try, both of you, she says, I think need a restart, that you've had, she admits she's had a problem in the past. She wants to try to work with it.
Your Honor, we both just started drinking out, like, we ain't real bad drinkers, but yes, in the past, we was, addicts, I've been clean for a little over 4 years. That's all it took, was that one little mess up.
Okay. Tell me about your situation. Are you working, or what do you do?
I was working for Southern Hope, where I completed, but I doubt I have a job now.
When this happened, you were working there?
Yes.
On May 21st?
Yes, sir.
Okay. Do you have a medical card?
Yes, sir.
All right. Well, I want you to go get some treatment, but I don't think it should be at Southern Hope since you work there. I think it needs to be someplace else. And you live on County Road 1. Where do you live? So close to Chesapeake on County Road 1.
Yes, sir. Am I allowed to do outpatient? Where I literally just completed, about a year ago, we've been doing good. It's just,
Did you did inpatient at Southern Hope?
yes, sir.
Okay.
Where on County Road 1 do you live?
Right across from the school, the elementary school.
Okay, you're really close to the court then.
Yeah.
Okay, we'll send you to RRS. That's within walking distance of where you are, and it's not. Where's Mr. Gwynn? Okay, Mr. Gwynn, I want to refer Derek Lockhart to your facility. He's within walking distance. And I think what we'll do, I'm going to hold off on sentencing you until we get started on that and see where we go.
Do you have a phone number?
How best to get in touch with you, Mr. Lockhart? You got a cell phone?
I do, I don't have the phone number. I guess the best way to contact me is through, my wife Kelsey. Got that number still.
What's that number?
It's on that statement.
You know her number?
Not my heart, sir. No, I haven't been able to call no one or nothing since I've been here.
We have it.
Okay. The prosecutor has it, they're gonna give it to Mr. Nguyen.
Okay, thank you.
Okay, so I'm gonna release you on an OR bond, order that you go to RRS for assessment and treatment. He's admitted to relapsing, and I think your main problem has been is it just alcohol now, or in the past it's been other things too?
In the past, it has been other things.
I'll let you sign a $2,000 signature bond. You're referred to RRS for an assessment, and I'll sentence you later, so I'm going to set a sentencing hearing, and by then they'll have seen you a few times hopefully, and we'll know where things are going. So let's set a date. Let's see. June 17th for pretrial at 10 o'clock. Well, I'm sorry, sentencing. Sentencing at 10 o'clock.
Thank you, Your Honor. Mr. Lockhart, I'll be in touch.
All right, thank you, sir.
So you're going to get out here today, and there's no order for you to stay away. Just go to prison. Okay, that's all.
Your Honor, the only two we have left in Orange County Jail are Eric Hammond and Charles May, and I don't think we're ready to recall either one of those yet.
Okay, we'll go back to them later then.
On the Hannah, I have an explanation now about it's the Attorney General's office that is going to prosecute the case, and Bill Walton, it just happens to be Dick Walton's son, is and he would be able to appear by phone if we maybe had a conference in chambers, but he wanted to talk to me first before that, so.
All right, we'll deal with that at the end of the document.
Okay.
State of Ohio recalls Stacy Plummer, case number CRB 2489.
Okay, she says she has a prescription for the things she tested for.
Yes, Your Honor. I think she said that before she got tested.
All right, anything you want to tell me, Ms. Plummer?
No, sir. Matt Jones.
Okay, I'll impose a $100 fine on court costs. $10 days in jail suspended. Order you stay out of Walmart. Do 5 days community service on our community service program. 2 years level 4 or level 5 probation. Review hearing November 22nd of this year at 9 a.m. Finish everything before then, you don't have to show up. Haven't finished it, you gotta show up for the hearing, or get a warrant if you don't show up.
So
Go talk with Mr. Major in probation and get your judgment entered before you leave.
All right, go right over there to right on the left, that's probation.
Thank you.
You are.
State of Ohio versus James Dement, case number CRA 2429 and CRG 231859A and B. Tyler Smith's case.
All right, we need Mr. Smith in the courtroom. This is on the docket as a preliminary hearing today.
Okay.
SDTC,
Yes, Your Honor.
I don't believe there's a written report.
There isn't.
you can give a verbal.
Yes, he is compliant with all recommendations for services.
How's the state want to proceed with this?
The state is okay with continuing to allow Mr. Dement to go through his treatment if he's willing to waive time until the next hearing.
And keep it in this court?
Yes, Your Honor.
All right, we'll waive time, Your Honor.
All right, thank you. June 17th.
Thank you, Your Honor.
June 17th will be the next hearing.
All right, thank you, Your Honor.
Start, Mr.
Thanks a lot. Thank you.
You're welcome.
State of Ohio recalls Kerry Beth McCoy, case number CRB 24227.
Mr. Worford's case, set for pretrial.
Judge, I'd like to ask you for a short continuance. She's indicated to me she wants to watch the video of this before she decides to plead.
All right. June 14th.
It'll be in office before June 14th. That's good, Judge.
June 14th will be the next hearing for pretrial, 10 o'clock.
Thank you, sir.
You're welcome.
Thank you, Judge.
You're welcome.
Thank you.
State of Ohio recalls Dana Howard, case number CRB 24235.
We didn't do a no contact. So, Your Honor, having had a chance to follow up on this, the only other thing we need to do is for Mr. Howard to get his stuff. And Ms. Boyard is agreeable to that. There was somebody who was here previously, a couple of hearings saying.
The last hearing when he didn't show up.
Yeah, so whoever that person is, could arrange with her to get his stuff and get it out of there.
Does he know who that is?
Eric.
Yes, I do, and I will go to his place and contact him today.
Okay. So how do we want to proceed? Do we want to keep this on the docket, or can it be completed now?
Did he get sentenced already?
No,
Yes,
we're
I
set
did.
for sentencing.
Okay. So what we had agreed to before was a suspended jail sentence, and he pled guilty in order to stay away. And so I don't have any specific, let's see, 60 days suspended, I guess is what it was.
Yes.
Okay.
That's what we would ask for.
We would join that recommendation.
All right. Anything you wish to say, Mr. Howard?
No, sir.
Okay. I'll impose a $150 fine where you pay court costs, 60 days in jail, all suspended on the condition you stay away from Mrs. Bolyard. 2 years of level 5 probation, review hearing November 22nd of this year at 9 a.m. If you have no further problems, pay off your fines and costs, you don't have to come to the hearing.
You have to, we're done, you have to step out.
He needs to see Mr. Major before he leaves.
Okay, that's over.
Yeah. Thank you, Your Honor.
You are.
Yes.
State State of Ohio recalls Kimberly Litchfield, case number CRB 24309, and Brandy Hodge, case number CRB 24308.
Well, do we know what we're going to do with Charles? I thought that's what we were waiting on.
We were, and I didn't get an answer back from Mr. Stonebeck, but Detective Lehman was going to contact, oh, I know, he did give me an answer. It's a common pleas holder.
Okay.
And so now we're trying to get in contact with the probation department, the common pleas court. Pardon?
We already contacted them. They're willing to keep the holder in place until they can get the drug test. They're trying to get everything done.
Okay.
So that'll be the earliest, will probably be next week.
Okay, so what we'd like to do, if it needs to be set for a trial next week, then we can do that, or if they would agree to continue it, we can do that. I don't know how to untangle the three of them, but we have a concern about Mr. May and not so much these ladies.
So it sounds like he's going to be probably in jail because he has a problem with common pleas.
Yes.
So do you still want a trial?
If it's on me and her, I don't care to drop it on her, but I'm not dropping it on him because he's the issue out of all of it. He's the problem.
So I think it's, if we continued it 1 week, then
Do you still want to continue with cases against them, or you want to drop their cases?
You know, it's not that I disbelieve this lady, but I don't know, I mean, he may have a different story about her involvement.
I'm okay continuing it. I'm okay with that, taking it to trial, like.
Okay.
And probably from our perspective, we won't end up needing to have a trial. But I think that that's the way to given the circumstances that we need to go.
All right, let's set it for trial next Friday, May 31st, at noon.
31st?
Yes, ma'am, 1 week from today. No bond required. This is a minor misdemeanor.
We both bonded out already.
Oh, you did?
Yeah, we both made bond
Yeah,
yesterday.
but well, see, they said they were going to charge you with menacing, but then they didn't. So
Right.
that was much more serious. So. Well, you have a bond up, but be back here next Friday at noon.
Okay. Thank you.
We'll try it. You're welcome.
State of Ohio versus Chad Spurlock, case number CRB 1952.
All right, you're Chad Spurlock?
Yes, sir.
Okay, this is an arraignment. It's alleged, this is an old case.
Yes, sir. Yeah,
January the 8th, 2019, in Fayette Township, it's alleged that you were knowingly using or operating a Dodge Caravan without the consent of Samantha Nelson, who was the owner. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead to this charge?
Not guilty.
Do you want a lawyer appointed to represent you?
Yes.
Do you have a job?
No.
You have no income?
Not at this time.
You have no income now?
No, sir.
Mr. Morford, I'll appoint you. Okay. You didn't get arrested on this, or why'd you come now?
No, I didn't know about it. Right after that, me and her broke up, and I live in West Virginia. I had some other trouble over there, and I ended up in prison right after that. I didn't know until I got out of prison. They, they run a background check and detainer checks on you before they send you out on parole, and they told me about it.
Okay. I'll let you sign a signature bond of $2,000.
Okay.
So let's probably go a month out to get the state, see if they even can get in touch with the person if they still want to go forward with it. June 28th?
That's fine, Judge.
June 28th will be the next hearing for pretrial at 10 o'clock.
Thank you, Judge.
Schedule 5 versus Andrew Carr, case number CRB 2427, set for 6.
Andrew Carr is on the sentencing docket today with Mr. Roger Smith as his attorney. And he's at TTC. Yes. Congratulations, Mr. Carr.
Thank you.
You get to see the baby?
Yeah, I get to see her every weekend. I'm getting ready to go tomorrow and Sunday. I get to spend 2 hours with her.
What's the baby's name?
Courageous Love Carr. She's beautiful, that's for sure.
I've seen pictures.
I heard.
Yeah.
Thank you all for them doctors and all that stuff, man. Like y'all was really a hand of God in all this, I know that.
Well, glad you're doing well. It's a good report. Anything else we need to address?
From our perspective, Your Honor, it looks like he's doing great. Got a lot more to live for now, right?
Yes, sir.
Do we want to, how do you want to go forward with this? He's already pled, it looks like, and I just set it for sentencing. I never have sentenced him yet. And I think the reason was, you had a bond up, right, at some point? I didn't want that bond to go away, so I wanted Mr. Sowers to chase you down if he needed to, and he needed to, at one point, didn't he?
Yes, sir.
I heard about the fiasco out on Route 60.
Yeah, we lost our vehicle and everything.
Yeah. But you maybe gained your life back.
Yes, sir.
You can always get another car.
I know that. I agree 100% with that.
You still have a monitor on him?
Oh, thank God, I got it off Monday.
Okay.
I go to meetings and stuff.
Okay, so I think I think we're far enough along, hopefully. I feel like you're committed to this and that you're sincere and you understand this is the best thing for you and your family.
Yes, sir.
And so I understand it looks like you're going to get to participate in a new program where they put the whole family together at some point. Got fingers crossed on that. So,
Definitely on the radar.
okay, let's, I think we'll go ahead and sentence him then.
No objection, Your Honor.
Okay, since I know you don't have a lot of money, I'm gonna make the fine $25
Thank you.
for you to pay court costs. But I'm gonna up the time, so I don't want you to go to jail, but I want you to think, if you ever think about, I think I'm gonna take off or I'm gonna go use or whatever, you got 3 months in jail, so 90 days in jail. I'll suspend 90 days. And I hope you never see the inside of the jail again.
Me too.
It's in your hands, you know. It's up to you, so you can make that happen. I'm confident of that.
I appreciate
Building
that.
it right now. I think it's good for you to do the community service, is what everybody does, so let's make it level 4 probation now. 5 days community service, level 4 probation, complete treatment at TTC.
Yes, sir.
Part of your sentence. And then I'll set your first review. Let's make it the 1st of July sometime. Well, we'll be here July 5th. I know nobody's going to be happy about it, so why don't we do it then? It's not a holiday, so the court will be in session on July 5th. That's a Friday, July 5th. And that'll just be a review hearing. So, Mr. Smith, you don't have to do it.
Thank you, District, 9 o'clock.
9 o'clock, July 5th.
Thank you,
Okay.
Sir,
Good job. Keep it up.
thank you.
State Law versus Mandy Joe Hall, case number CRB 24116.
Mr. Smith's case, 7%.
She's at Mahajan, Judge, but I don't see anyone, of course, I could be overlooking for Mahajan. Nobody looks familiar to me from there.
Well, I'd like, because of her last screen, I'd like for her to do a screen today.
Okay, recall
Do
it.
a screen and we'll recall that for that.
State of Ohio versus James Kearns, case number CRB 24136.
Okay, so you'd already pled guilty. I delayed the sentencing because there might be some bills, so.
Yes, sir.
So, the prosecutor got anything on that? This is on a dog case.
I believe I was just given a jump. Cons. All right, so we've got restitution figures here. Was there a plea entered?
There has been a plea.
All right. So I've got 2 restitution papers here, one from Cabell Huntington Hospital and one from the Lawrence County EMS. And we would ask that those be ordered paid. One for $243.73 and one for $499.98.
Okay, and those are outstanding. There's no insurance or,
That is, if you look at it, it's what insurance covered.
Oh, okay.
Insurance covered that.
And there's still a balance.
That's
Yes.
what she is. That's what
Yes,
insurance
it was a
covered.
larger amount. In fact, we've got the documents to present to the court. The balance due is $243.73 from Cabell after insurance paid. And then the balance on it's still $499.98 from the ambulance service. So if I may approach, I can bring this forward.
okay, why don't you show them to Mr. Kearns first?
This is Cabell. 43.73. This is the ambulance.
Approach your honor.
Yes.
Is that what this is that I just got? Must not be. Maybe it is, I don't know.
That's on the ledger.
Okay, well, what say you, Mr. Burns? Are you agreeable to these amount, or do you want to have a hearing about it?
Yeah, I agree to it.
Okay. So let's see. It was $499.98 and $243.73.
I don't have it, oh, well, yeah, I do. 243.73.
Yes, I got it right in front of me. So that's a total of $743.71. Okay. Is there anything else you want to tell me about this?
No. How would I pay that?
Pay it to the clerk. And they'll take payments, but you'll make your payments here. That way there's a text you, because we'll have a record of what you paid going forward. Okay. I'm going to impose a fine of $100. Order you to pay the court costs. I'll order restitution in the amount of $743.71 to Jennifer Markowitz. You want me to spell Markowitz? Are you ready? M-A-R-K-I-E-W-I-C-Z. Okay. If you want a copy of that, you can either go to the clerk or the probation, get a copy of the judgment entry, but that's what you owe. I'll set a review hearing for November 22nd at 9 a.m. If you paid it off by then, you don't have to show up.
And that was, what was the date again?
November 22nd, 9 a.m.
And if I don't pay for it, if I pay for it, I don't have to show
You
up?
don't have to show up. If you pay everything off, you don't have to be here.
Okay.
That's all. You're free to go.
Thank you.
State of Ohio recalls Mandy Joe Hall, case number CRB 24116.
I haven't seen results, but I spoke with my client. She said it's positive for oxycodone,
Yes.
and she indicates she
I do not take oxycodone.
doesn't have anything
I
to mimic
take 2 drug
oxycodone.
tests a week at my doctor's and it never shows up.
What about benzodiazepine?
Yes, I have a prescription for that and the Suboxone. They were supposed to fax my papers of my medication and a report.
And I checked her this morning, Judge.
Okay.
It was not here when I checked, but that's
I want a
been.
copy of this sent to Mahajan. So, and I want them to appear with you the next next time. Do they just have somebody drop you off and take?
No, I had to bring a cab that was $40, and I'm gonna take a cab back that's $40.
Okay. You want to stay there, or you want to go someplace else? I'll let you go someplace else if you want.
Where at Mahajan's?
Yeah, go someplace other than Mahajan.
You want me to go somewhere else?
What you
Yeah.
asking you, do you,
I kind of do.
I can, yeah.
you got other
Okay.
programs that
You
are
got,
here all the time.
anybody got a bid? Okay, let's have you talk to some folks, see if we can get you somewhere else.
Recall judge.
Yeah, let them look at the file to see what the allegations are and tests.
The State of Ohio recalls Charles May of the Lawrence County Jail, case number CRD 24307.
There he is. All right, Mr. May, I don't think I arraigned you, so and let me just tell you, it's my understanding, what I've been told is that you have a holder from common pleas court over something that's going on there. So this won't. Okay, I don't know. That's what I was told. There was a holder from common pleas court. Are you on probation from there, or have a pending charge? Okay, it's probably from the probation. What you've got in this court is a disorderly conduct charge. It alleges that at Perry Township on May 23rd of this year, you recklessly cause inconvenience, annoyance, or alarm to others by engaging in fighting, threatening harm, being violent and turbulent. The maximum I can do on that is a $150 fine. So, do you understand this charge?
Yeah.
Do you understand your rights?
Yeah.
How do you plead to this disorderly conduct charge?
Guilty.
Guilty means you're admitting it's true. Okay. Well, I'm going to give you a $150 fine and order you to pay the court costs. The women are going to want a trial. They're going to have a trial on next Friday.
They may not at this point.
I thought if he's smart, he'll just plead guilty to this.
Yeah.
There's not a whole lot I can do to you. You get a fine, court costs, that's it. I can't even put you on probation. So, there you go, you got a fine, court costs. I would ask, and you know, I've made women mad before. You've made 2 women mad. So,
One of the girls is my girlfriend.
okay, well, I don't think she's that happy with you either. So you're going to be, I don't know if you, once you get out, eventually, they're not going to keep you in jail forever. But this is like, I'm a lot older than you, I've kind of figured this out. Life is a lot better when you keep the women around you happy. When they're not happy, life is not going to be very good. And you've got 2 that are not very happy with you. So whatever you're doing something wrong. You need to adjust that. Just remember, that's your number 1 thing, rule. You're dealing with your wife, your girlfriend, even your neighbors, whatever the women, do not make them mad. Whatever you got to do, keep them happy, and things will go a lot better. Okay? Okay. All right, we're done. On him? Yeah. He's already promised.
State of Ohio versus Jeremy A. McMillan, case number TRC 22769 A, B, and C, TRC 202410 A, B, and C, TRC 192341 A, B, and C, TRC 14.
Yes.
Judge, I had this, not for today, but apparently it was moved up so he wouldn't miss work, so I'm available. I'm here.
Okay.
I just don't have his file.
Yeah,
but
I think it was originally said on the 20th.
I'm very familiar, I don't need his file.
He has to come in so that he would be able to work more days
Not a
next
problem.
week.
Okay, he had a good report, and I've got a text from Mary Smith that I was going to read into the record. If I can find it. Get so many, but Yeah, I did find it. Okay. This was to me and to Kim. It says, today Jeremy McMillan has been with us 1 year from his prison release. Despite Judge Ferguson's deep reservations, and largely due to Judge Kapler's advocacy, this guy has excelled at Bethesda. We are tremendously proud of him and his hard work. Thank you for allowing us to be a small part of his recovery journey. So,
Thank you.
and I feel the same way. In this endeavors, we have some failures. We have to hold on to the successes, and you're one of the successes that keeps me going. If I didn't have somebody like you to come along every once in a while, I'd probably just say, forget it, I'm done. I can't handle this anymore. But you keep me going, Jeremy, and I appreciate that. So, no pressure, but you know, you fail, I might fail. You know, you're what's holding me up, so you keep doing what you're doing.
Sir.
Okay?
Thank you.
So we'll see you in maybe 6 weeks.
Sounds good.
Let me give you a date.
Thank you. Hang on.
Wait, I gotta give you a date to come back. You're not done. I promised Judge Ferguson I'd keep track of you for a long time. I mean, you'd just be a newbie at the prison he sent you. So we gotta keep going for a while. How about July the 8th, Mr. Smith?
Yes, Judge, I'm available.
All right, July the 8th will be your next hearing.
Thank you, Your Honor.
You're welcome.
Are these sentences on review?
Yeah, we'll call him sentencing. We want Mr. Smith to be here.
State of Ohio versus Matthew Smith, case number CRB 21692, CRB 15457, CRB 14553, CRB 14665, and TRC 12627. I'm not sure what's going on.
I'll put him in the back. Okay. All right. So I'm looking at your hands. Does a weed eater fit in those hands?
Yeah, they do, Your Honor. They do. I was told misunderstanding. I have no problem working tomorrow.
I need you out here tomorrow. The weeds are growing like weeds. It will grow, especially when it rains like it's been raining, and we got some weed chopping to do.
Yeah, it was told misunderstanding.
So you'll be here at 7:30 a.m. in the morning. Okay, I'm going to believe you. I'll release you and set your next hearing for June 24th for review. June 24th. That needs to be released.
Judge.
Do we want to get Mr. Walton on the phone?
What I'd like to do, Your Honor, is call him first of all, and I think it's possible that we won't need to have the hearing at this point.
Okay.
So if I could be excused to call him.
I think that's all we got that we can do for now. Is there anything else we can do? Mandy Hall was talking about switching, going to a different facility.
I have an assessment now, I think.
Okay, so.
Mark Jude as well, Your Honor. I don't think he's reported.
Who's that?
With trial. Mark Jude.
Is set for trial today?
Yes, Your Honor.
And he's not here?
No.
Yeah, he was here earlier.
He's right behind you.
Sitting right there.
Well, I told you we didn't report. Okay.
Why don't you talk with him, we'll take a recess and come back.
Yes, sir.
Okay, court's in recess.
You give me a one. Yes.
I'll let you give them all that.
No.
Say this is my name, right? Talking to you about some churches.
Orland, I'm glad.
It's going to be fun. Yourself on the phone.